We now have a quorum and we'll begin the COPRAC meeting. This meeting is being recorded. Before we do roll call, we ask that anybody who plans on giving public comment to please use the raise hand function to indicate you'd like to speak. Now, with permission of the chair, I'll take roll call.
Yes, please.
Okay, Justin Fields,
Here.
Ken Bacon,
Here.
Sarah Benola,
Here.
Elizabeth Bradley, Cassidy Shivers,
Here.
Toby Inlander,
Here.
Brandon Krieger,
Here.
Joel Mark,
Here.
Eleanor Mercado, William Munoz, Dina Roach, Kyla Rowe,
Here.
and Hunter Starr. Okay, thank you.
Was there any public comment?
Let me check. Again, if anybody in the public would like to give a comment, please use the raise hand function right now. It does not look like we have any public comment.
Great. So I guess next we would approve the minutes from our July meeting.
Yes, is there a motion to approve the minutes from the July meeting?
So moved.
Was that
Toby.
Toby? Okay, and a second.
I'll second it.
Thank
Kyla.
you, Kyla. All right, I will take the vote. Justin Fields,
Yes.
Ken Bacon,
Yes.
Sarah Benola.
I missed the July meeting, so I guess I'll abstain.
Okay, Elizabeth Bradley, Cassidy Shivers,
Yes.
Toby Inlander,
Yes.
Brandon Krieger,
Yes.
Joel Mark,
Yes.
Eleanor Mercado, Bill Munoz, Kyla Rowe,
Yes.
and Hunter Starr. Okay, the motion passes.
All right. So I think next, if we have any announcements or report from anyone from the state bar.
Sure, thank you. Good morning, everyone. I just wanted to make a brief announcement. There's another face on our Zoom this morning, and that is Kathy Ongiri. She is a new staff member in the Office of Professional Competence, and she is a senior attorney in our office who will be leading several of our e-learning projects. And she may be collaborating with COPRAC on possible future education projects and other assignments. And so I just wanted to give a brief introduction, and Kathy, you can give a bit of your background if you'd like.
Good morning. Thank you for having me. Prior to coming to the state bar, I worked at the Judicial Council, and I did judicial education in the areas of access, ethics, and fairness. So I'm really excited to be here and work with some education with this committee. And thank you for welcoming me.
Thank you very much, Kathy. It's nice to meet you. And just looking at this Zoom window I have here, I mean, the resources that we get from this committee and time from the state bar and its staff is apparent, and we appreciate it. And we look forward to working with you. Anything else, Erica, Randy, Mimi?
That was it this morning, a brief one. Thank you.
Okay.
I'm going to just mention one thing, if that's all right. You guys will notice that the meeting minutes going forward will look a little bit different. They're trying to standardize them across all the committees. So don't be alarmed that it might look a little bit different than we're used to. So I just wanted to let you know that since we will be approving, going forward, it'll look significantly different than what we had previously.
Thanks. So this is our last meeting of the cycle for this composition of this committee. So we have a somewhat light schedule. I think we'll cross our fingers. I think we're going to move pretty quickly today, and we have a couple folks who are out or joining us late. So that's also, I think, going to make the agenda move a little quicker than maybe we anticipated. So with that, I think we should just dive into it and start with 20-001, lawyer as expert witness. So for this one, Sarah, if maybe you could kind of refresh the members as to where we are and what changes have been made since we last discussed this opinion and then we can open it up to comment.
Sure. And although I had to miss the last meeting because I was in trial, I did coordinate with Justin after our July COPRAC meeting. And then based on that, I was able to make some of the edits that were recommended at our last COPRAC meeting based on the discussion then. So I'll go over the significant edits. Some of them were just kind of cleanup and removing some duplication to streamline it, but I'll go over the substantive changes that were made. And the first, as you can just see from the screen share, is just narrowing the discussion of the issue. And I understood that was something that we discussed in the last meeting, to keep it simple. And so that's what the first change is doing. And then we go into more detail in the digest. The second change that was made was around page 4 of this red line draft. And that was, there was a significant discussion of the American Airlines case and an attempt to distinguish it, where American Airlines held that a lawyer who acted as a Rule 30b-6 person was qualified witness in a matter that was adverse to American Airlines, that acting in that fiduciary role violated the attorney's duties. The members of the last meeting didn't really feel that this discussion, it was too long and that it didn't really fit clearly where it was. So they recommended it either be shortened or moved to a footnote. So I moved the discussion to a footnote and shortened it significantly. And I believe that's appearing in footnote 5. You'll see some other, before we get to footnote 5, you'll see some other edits right before that I think were just kind of minor, adding some parenthetical descriptions. So footnote 5 is where I think the American Airlines discussion is incorporated. So I'll just pause there. So, but it basically is just distinguishing it very briefly. The holding that a lawyer breaches fiduciary duties to his former client by serving as a federal Rule 30b-6 witness in a matter adverse to American Airlines is not contrary to her conclusion, and then distinguish it because there the Court of Appeal held that relied on the fiduciary duties that the PMQ witness owes to the company. And in our situation, a lawyer acting as solely as an expert witness does not generally assume a fiduciary relationship with the client. So we felt it was better to put that in a footnote. So before I move on to the other change, I'll just pause just in case anyone has any kind of thoughts on that particular change. So not hearing anything, I'm going to move on to the third change, which is on page 7, where we talk about even in situations, it's kind of towards the end where you'll see the red line, but that you had it in the right place, Mimi, but very much. But basically we were talking about, even if in this situation, which was scenario 1, where it was a lawyer then testifying expert, even if that situation didn't result in a violation of the rules of professional conduct, that there could still be a disqualification risk under case law standards. And so we wanted to reference the relevant case law discussing the disqualification standard in this type of situation. And we tried to include, this was based on the discussion of the last meeting, a discussion of the case law addressing that in more detail in scenario 1. And that way, when we get to the scenarios 2 and 3, it's more streamlined and we just cross-reference that discussion. So that's all that, the red line is just expanding a little bit on the disqualification risk here in the case law so that we can cross-reference it down below. And then the next change is on page 9, and this is something that might warrant a little bit more of a discussion. And so this was, I wasn't at the last meeting, but I understand there was a discussion about the imputation analysis and perhaps it not being precise enough. because we didn't talk about the sharing of legal fees and whether there should be a prohibition on the sharing of legal fees. Based on my interpretation of the applicable rule here, 1.10 A1 is what we're applying here. That doesn't really involve screening. That involves the personal interest of the lawyer, where there's conflict based on the personal interest of the lawyer. And that particular rule does not require screening, or the tainted lawyer be prohibited from sharing fees. That's really addressed later on in paragraph A2, where the conflict is based on former representation, based on Rule 1.9A or B, and arises out of the prohibited lawyers association with the prior law firm, where the lawyer didn't substantially participate in the matter. So that's the rule that it addresses kind of the prohibition on sharing fees and what goes into screening, but not 1.10A1, where screening wouldn't be required. So I didn't think we needed to go into any detail on the prohibition on sharing of fees, because I don't think it applies, the portion of the rule. So I'll just pause on this, because I don't know if someone else has different thoughts on if they believe that 1.10 A2 applies, or if screening would apply here. I'm not saying it wouldn't necessarily be perhaps the best practice, but I don't think it's required under the rule. So I didn't want to incorporate it here.
So I can't remember if it was maybe Ken or Joel who raised this question. Not to put you on the spot, but I'm wondering if this sort of satisfied the query that you had about the fee sharing, or if it was anyone else, if you want to weigh in. It seemed to satisfy me, but I don't know if other folks were looking at this from a different perspective or angle beyond the answer that Sarah provided, which seems responsive.
I don't remember if it was my either, but that seems to address it from my perspective.
Okay.
Great.
And the next revision, which I think this was based on Justin's follow-up comment after the meeting, which is where he felt our discussion of Rule 1.4 dealing with the duty of communication, that could use some more analysis. So that's addressed on page 11 of the draft opinion. I think it's page 11. Huh. You know what, actually, I'm sorry, page 10. I'm looking at the wrong. Okay, yeah, so I think right around line 272 is where the addition is made to expand on potential application of Rule 1.4 to say that in this scenario, which is scenario 2, the law firm should disclose any significant disqualification risks to its client. And then this is based on if the expert is subject to ongoing contractual duties of confidentiality to the plaintiff, explaining the risk of disqualification. And to the extent here that, sorry, I'm skipping ahead, but first the Rule 1.4b application was addressed, which requires the lawyer to explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So in this case, disclosing the disqualification risk in this situation would assist the plaintiff in doing so. And then second is to the extent that the current client expected the lawyer to reveal confidential information, or the law firm to reveal confidential information in breach of the expert's confidentiality obligations, the law firm would be required to disclose inability to do so under Rule 1.4A4, which is quoted in the parenthetical here, which requires the lawyer to advise the client about any relevant limitation on the lawyer's conduct. The lawyer knows the client expects assistance not permitted by the rules of professional conduct or other law. And so here it would be the other law, the contractual duties. so that the expert owes to the former client. So I think those are the subsections of the duty of communication that I thought were potentially applicable here, 1.4b and 1.4a4. I did not believe that the other subsections of A applied. And I do not think that this duty of communication necessarily applies to the other scenarios based on the facts. But I'll first just see if anyone has any thoughts on including the discussion of 1.4b and A4 and if it seems applicable here. You might have to go, if you scroll back, actually, I might have to look at my own draft real quick. Give me 1 second. Even with the reorganization, I forgot it. So this scenario too, just to remind everyone, was the testifying expert first and then the lawyer.
Organizationally, I mean, if others felt this should go somewhere else, please weigh in. It seemed to flow to me in terms of how you ordered it. And I would just say, I think so somebody else's good idea, not mine, to add 1.4. The only comment I had is in this new section is, seems like the first few sentences of this paragraph are tied to disqualification, but the sentence starting in the red line at 279, in addition, if law firm knows, seems like that's moving away from disqualification and talking about 1.4A4. So I'm wondering if we want to break this up into 2 paragraphs right there.
Yeah, I agree with that suggestion. That makes sense.
That's all I had.
Okay. And then, make sure. The next change is just consistent with what I just said, which is on page 11, where I just removed the discussion. And if you scroll down a little bit more on page 11, I think it's towards the end here. We had a sentence about the potential need to disclose the disqualification risks to the client under 1.4A or B. And after evaluating this more, it doesn't appear that paragraph A or B would apply in scenario 3 or scenario 1, but in this section, we're talking about scenario 3. So I removed the discussion about a potential duty under 1.4. And again, I've got to remind myself, this dealt with the concurrent testifying expert and then the law firm representation, where the expert was retained as a testifying expert witness whose testimony would be adverse to the company, a current client of the law firm, but the matter where the expert will testify adverse to the company is separate and entirely unrelated to the matter in which the law firm represents the company. So it didn't seem applicable to disclose the potential disqualification risk in this type of situation, where it didn't seem like it would apply necessarily under the relevant ethical rules or the case law.
Isn't there something more that I'm just looking at that scenario? It's not just disqualification. I'm wondering on the communication issue. If the expert,
Let me pull it.
let's see, lawyers at the firm and testifies an expert against company, which is a current client of the firm. I guess in my mind, there could be an issue if that relationship comes out at trial. The fact that the lawyer is testifying adverse to a current client might give undue weight to the testimony by the opinion testimony of the lawyer. Maybe that's something that should be disclosed. If you've got law firm is representing the company and then a lawyer from the firm is testifying. One minute, okay, separate but oh, okay, I'm sorry. So I'm just getting back from vacation. So the matter of experts testifying is not the matter where the law firm is representing the company. Okay, sorry.
Yeah. They're separate and unrelated matters.
Okay, and that was the one thing that was kind of sticking in my mind is whether, the lawyer testified as an expert gets maybe some undue weight or credibility just because they're taking a position where they're not testifying adverse to a client of the firm. I guess one could argue that implies, I don't know, they're stronger beliefs or feelings to take that risk or something to that effect, but that was kind of the concern.
I don't see how that scenario could ever be beneficial to a client. I mean,
Yeah.
so.
Yeah, I don't either. That's why I was just wondering if maybe that's something that needs to be disclosed.
And under what subsection of the duty of communication do you think the disclosure obligation would fall?
Informed decision regarding the representation. You might not want to have the law firm be your attorneys if one of their lawyers is testifying against you as the client.
So are you looking at, do you mean subsection A, which is inform the client? Because I don't think it's subsection A necessarily, because that's where informed consent is required by the rules of the State Bar Act. So I don't think it would be there. There's also reasonably consult with the client about the means to accomplish the client's objectives, which doesn't really seem to apply, or a significant development is subsection 3. And then 4 is the one we discussed in connection with the prior situation, relevant limitation on lawyer's conduct.
I was looking at 1.4B, just the duty to communicate.
Oh, to make things, oh yeah, to make the clients make informed decisions regarding their representation.
Yeah.
Yeah.
That makes
Okay.
sense.
Maybe the law, it should be conveyed to the client that, the fact that there's a lawyer testifying against the client.
I see what you're saying. Yeah.
Gives them, and that, that could, have undue weight or credibility, and then maybe they just don't want the law firm to represent them.
Yeah.
So are you, it's very hard for me to keep track of these scenarios. So forgive me if I'm way off here, but Ken, are you saying that in the scenario that you're talking about, the lawyer, the law firm and its lawyers who are representing the client who are actually the lawyers representing the client in some litigation matter would want to explain the pros and cons of continuing with that law firm as counsel because some other lawyer in their law firm is serving as an expert against that same client in an unrelated matter?
Yeah, it just occurred to me that, from a communication standpoint, that might be something the client would want to know. They can decide whether they want to have the law firm continue to represent them. It occurred to me as we were talking about scenario 3. I haven't gone back and analyzed it on the other scenarios. Again, it's hard for me to keep track as well. But
Yeah, I guess to me, it also ties into 1.4A4 in that, and maybe for me more so, in that if it's a completely unrelated matter and the expert who's also a lawyer at the law firm has nothing to do with the litigation matter that we're talking about, where the lawyer is actually representing the client. The one concern I would have is that there's some kind of friendship, professional relationship between the lawyers at the law firm, where in the lawyers who are actually serving as litigation counsel as opposed to the expert might in some way be limited in how they conduct themselves because of what they know is going on with the other case where their colleague is serving as an expert. And so in that, I think it's a somewhat strained hypothetical, but I guess possible that there could be an issue there. And I guess in that regard, 1.4b, I mean, if it's necessary to, if that relationship could in some way impact the client in the litigation matter, the client would need to know that information to make informed decisions about the representation. So this is sort of a long way of me rambling and saying that I see that same discussion about 1A4 and 1B that we just looked at previously as potentially relevant to this scenario. And so maybe we want in some manner to flag that same analysis that we looked at it around line 270 and 280 applies to scenario 3. Is that kind of what we're getting at?
Yeah, except that, like I said, it's not limited. I think the discussion we had, was disqualification risk. This wouldn't necessarily be a disqualification risk, but it's something that could impact, be significant to the client and wanting to make a decision about this law firm and whether to have them represent them.
I actually think, Justin, you raise a really great point when you think about, the limitation on attacking the opposing expert's resume and credibility if it's your own firm is kind of leaps to mind. I do think that's worthy of disclosure.
Oh, yes. Sorry, Brandon, go on. I didn't mean to interrupt.
Oh, no. And I was just going to agree with Ken's point that there's sort of I've always thought Rule 1.4 requires disclosure of things a client would want to know. And they might want to know that the law firm that they're paying is going to be putting on an attorney testifying against them. But that's a little nebulous.
I can see I understand the feedback. The other thing, though, based on what Justin was saying, though, if that truly were the situation where the let's say the lawyers representing the company here have a really close relationship with the expert, and somehow based on that relationship, and maybe even the expert's getting a lot of fees, let's say, from this matter, so it's a key matter where the expert is testifying. If there truly were a situation where that was imposing a limitation on the law firm's representation of the company, then I don't think it's just a Rule 1.4 issue. I think you also have to look then at potentially Rule 1.7 and 1.7, I guess the material limitation subsection, which is 1.7b, which a lawyer shall not, without informed written consent from each client, I'm trying to see if that would apply, represent a client if there's significant risk that a lawyer's representation of the client will be materially limited by the lawyer's responsibilities to or relationships with a third person, or by the lawyer's own interests. I mean, it also says client, former client, or third person, or by the lawyer's own interests. I don't think it's necessarily based on the facts we have here. We haven't put them in the hypothetical, but if those facts that Justin were contemplating existed, I do think there's a potential application of 1.7b, not just 1.4. And looking at 1.4 again to try to understand. I understand Ken's point about 1.4b. You know, this might be help the client make an informed decision regarding the ongoing representation, this type of disclosure, but 4 deals with disclosing relevant limitation, 1.4a4 on the lawyer's conduct. The lawyer knows the client expects assistance not permitted by the rules or other law. So I'm trying to, Justin, I'm just not quite seeing a clear link to 1.4a4 here.
To 1.4a4.
Yeah.
Well, so I'm tying it to what you're talking about with respect to, I think, 1.7b, this whole concept of some kind of material limitation because of the relationship between the lawyers in the litigation matter and the expert of the same law firm in the separate unrelated matter. If their relationship in some manner would limit how the lawyers litigate on behalf of the client because they don't want to upset their colleague, you know, again, these are very strained facts, but in that strained hypothetical that is unlikely, then there would be, it seems, a duty to advise under 1.484 about this potential relevant limitation on how the lawyer would conduct himself or herself. So that's the connection I'm making in terms of 1.
Yeah, I get that.
Now, I think it's very strained, and maybe I regret bringing it up, but I also think it's in some manner encompassed in what we already say in scenario 3 around line 322. We do say that 1.7b and this concept of material limitation is potentially implicated, though unlikely. And I don't think I'm saying anything different than that. I think I'm just kind of posing a hypothetical where the material limitation might apply, both in terms of 1.7b, but also in terms of the duty to advise about a potential limitation on the lawyer's conduct, i.e. because of this relationship between the lawyers.
Yeah,
Sarah, I mean, if you look at 1.7b, which I was thinking is along with Sarah really does apply, drop down to 1.7c, which says even when a significant risk requiring a lawyer to comply with paragraph B is not present, the lawyer shall not represent a client without written disclosure of relationship where C1, the lawyer knows another lawyer in the lawyer's firm has a legal, business, financial, professional, or personal relationship with a party or witness in the same matter. I mean,
so this is not the same matter, though.
That's not the same matter.
well, no, if I'm testifying as an expert against a client of my law firm, and I guess that is another lawyer that I have a relationship with, or they have, my law firm has a relationship with me that has an adverse business relationship because I'm getting paid to testify against their client. So I really think it's something I don't think any expert should try and get around, or a law firm should fail to disclose and decline.
I don't necessarily disagree that it maybe should be disclosed, but I don't think the disclosure obligation falls under 1.7c1. And we do analyze that in on the page that's on the screen now, potential application of 1.7c1, but because it's not the same matter, we conclude that this written disclosure obligation does not apply here. I don't, I tend to agree with that the potentially 1.4 duty of communication would apply in this type of situation. And I'm not sure if we really go into the material limitation, Joel, the comment as much here. And I do think based on what Justin was saying, we might want to expand a little bit on the analysis and add some of the potential facts, that could lead to a potential application of 1.7b and then 1.4a4. And Justin, just going back to the question I raised to you about, because I didn't get a chance to respond right after you were explaining how you thought 1.4A4 applied. My only hesitation still on that is, it says when the lawyer knows that the client expects assistance not permitted by the rules or other law. And here it's not that the client here that would expect assistance. It seems like you'd be talking about I don't see how that applies to our facts.
I see
It's
what
not
you're
as
saying.
if the client of the law firm isn't expecting, they're expecting the lawyer to represent them consistent with the duty of zealous advocacy and not to have any material limitations on their conduct. And the expert's client in this situation isn't necessarily expecting assistance not permitted by the rules. That's on an attorney-client relationship. So that's why I'm having a hard time seeing the application of 1.4A4. I agree with you that it could be a material limitation conflict type situation, but I just don't see, based on the language of A4, at least the second half of that A4, which talks about when the client expects assistance not permitted, then the disclosure obligation arises. I do agree that subsection B could potentially apply. But Justin, do you feel, I don't know, looking at that language that I just focused on in A4, do you feel that it still applies?
Yeah, I see what you're saying. I'd have to give that a little more thought. I was more doing a mental exercise trying to tie some of these concepts together on the fly that we were talking about in terms of 1.4 in some manner being discussed here with scenario 3. I could keep going here and try to push it further. I look at also 1.4A3, keeping a client reasonably informed about significant developments. I think one would colorably argue that if the lawyer representing the client in the litigation matter was in some manner going to be materially limited in how he represents that client because of his professional relationship with the colleague who's now serving as an expert against the client in another matter, that would be a significant development. So I guess what I'm saying is, I don't know that we need to get bogged down in whether it's 1.A1, 2, 3, or 4 that applies. I think it's more of, we feel that there is some kind of interplay between 1.7 B, if there is a material limitation, and the need to communicate that material limitation and obtain whatever consent might be required for the representation to proceed after making the required disclosure. So I'm not necessarily tied to 1A4, but I do see, some value in reinforcing the discussion that we already have here around 322 and the 1.7B discussion, and interplaying it with the duty to communicate, because those do seem to be related, and we've in some manner related them already in the prior section. Which to me suggests we don't need to do another full-blown 1.4 discussion, but perhaps it's whether it's a footnote or something short, there does seem to be an interplay there to me, worth exploring.
Okay, I think that makes sense. And so I think for the next draft with the subcommittee, I'll try to work on expanding on potential application 1.7, giving a little bit more of a factual analysis, and then addressing Rule 1.4 briefly. And just, I think there was only one other change made. Let me just double check. Yeah, and this was one that I was, I don't know who recommended this last meeting, but I thought it was a great recommendation to remove scenario 4 altogether. I always had trouble. I was kind of tracking the difference between scenarios 3 and 4, and I felt that it was confusing and it was difficult to distinguish the two scenarios. And I think at the last meeting, I understand people felt similar, and also felt that it didn't add that much value by having the additional scenario 4. So based on those comments, I just took out scenario 4 altogether. And I think it's helpful because I think it's already hard to keep track of the different scenarios as we're going through the analysis, and adding a scenario 4 that it's just so close to the third scenario, it really, I do think, makes the opinion a little too confusing. So that was removed. So those were the key changes that were made since the last meeting. And I think really the focus for the next draft will be on just the scenario 2 edits that we just went over. And I don't have anything else, but I'll pause to see if others, based on the agenda materials, had any other comments or proposed edits to this draft opinion.
Well, thank you, Sarah, and the subcommittee for really retooling this. I think it is much closer to the public comment stage than we've been in prior iterations. And I do think that, you know, there's probably some benefit because we have gone through this many a time to at least try to target the, you know, one final round of editing and discussion, and then hopefully we'll be in a position where we can send it out to public comment. I only had one other comment on what was line 72. It's before it's here, the lawyer experts expressly disclaimed. I think this is just a matter of the, you know, the reorganization. We start getting into the fact pattern before we get into the actual scenarios later on. So we might want to either reorganize or just add some kind of transition to say that, you know, here, you know, under the factional scenarios presented below, so that it there's some transition to the fact that we're now talking about the scenarios in our opinion. If we want to leave it there, that might be a simple way to just transition the reader to know that right now we're telling them about some facts that apply to the scenarios that they're about to hear about. So something like here under the factional scenarios presented below, something like that. That was the only thing that struck me that I wanted to flag.
That makes sense. And I don't know if that's, Mimi, I think you're the one who's helping. If you could move that particular comment that you highlighted in green to follow here, because I think that's the place where Justin's suggesting the transition be. That will just help me when I work on the edits next time to remember. Yeah.
And if you want to, whoever that was, Mimi, Angela, the proposal I had, which I'm not wedded to, but just so you have it when you look at this again, was here, comma, under the scenarios presented below, or something, yeah, under the scenarios presented, something along those lines, just to transition the reader to you know, our more formal discussion about to then getting into the actual facts of our scenario. Anyway, it's minor, but that's all I had. Do others have comments or questions for the subcommittee? We've still got 44 minutes that we can talk about this opinion under the agenda. So really, anything, taking stuff. We got time.
Yeah,
No?
I tend to be concise with my commentary, but the only other, I do have one other comment that actually would be helpful, because we went into the discussion about potential application of 1.4 to scenario 3, and we discussed this application of scenario 2. I think before the next meeting, if the subcommittee members could also further analyze the potential application to scenario 1, because I think we should just evaluate that again as well. And I don't think we need to necessarily get in. I mean, we could talk about it briefly now, if you'd like, if we do have the more time. Which scenario 1 is a lawyer then testifying expert, where the law firm represents the company in a lease, and then the law firm learns confidential information about the company's business model, and then subsequently, after the attorney-client relationship has concluded, the company sues a competitor alleging misappropriation of trade secrets, and the expert, a lawyer at the law firm, is retained by the party opposing the company in that trade secret action to testify against the company regarding business valuation and damages. And so in that type of situation, do you folks feel that there is a potential application of Rule 1.4 here, because the representation has concluded? I don't think that Rule 1.4 would necessarily apply here, but I welcome feedback on that.
And that might be right. I mean, I have 1.4 up here, and that was where I was going to go as well, because it's not like the concurrent scenario we talked about with number 3, where there's an active lawyer-client relationship ongoing at the same time that the expert is working on another matter against the firm's client. 1.4 talks about a lawyer shall communicate this, that, or the other. Well, there's no concurrent lawyer in this case at the time in which there's the concern about disclosure of confidential information in scenario 1. The person that was the lawyer is now just an expert, or purportedly just the expert. So
yeah, I think it is more straightforward here in scenario 1, and I don't think it necessarily requires an analysis. I was flagging it because initially I didn't think it applied to scenario 3, but I am persuaded based on our discussion of this meeting that it does potentially apply to scenario 3 at least. Okay, well, I don't think there's really anything more on this opinion. If we want to move on to the next agenda item, Justin.
Sure. So like I said, I thought we would move quickly, and we are. Just anticipating that cryptocurrency will go quickly as well, because Eleanor and Bill weren't able to make it, and I'll cover that for them. That I think we should plan before lunch to then just move to the civility rules of professional conduct discussion if we have time before lunchtime. So thank you again, Sarah, for leading that discussion. And why don't we move to the draft of the cryptocurrency opinion. And I haven't had a chance to talk with Eleanor or Bill about this. I think they were hoping to attend sort of last minute. Didn't work out today. But my understanding is that there's maybe been some limited cleanup done from the prior opinion, that a draft that was circulated and discussed briefly in our July meeting. I think it's still, very much in the early drafting stages. And so what I was thinking we could talk about is some more high level concepts in terms of helping them clean up and refine the discussion. One thing that came to mind for me, I think Bill and Eleanor mentioned that they had, in the July meeting, that they had begun drafting with the idea of not using hypotheticals. And this is a discussion point we also had, you might recall, with the conversion clause opinion. And at least for that one, we left in the hypotheticals. And here, well, I'll refrain from tainting the conversation with my opinion till others have a chance to weigh in. But I think it would be helpful to get the committee's feedback about how this is presently reading without hypotheticals. And, if you feel that it would be either better to organize the opinion on cryptocurrency around hypotheticals, if you like how it's currently drafted, or something in between. I think that would be helpful feedback for Eleanor and Bill. So why don't we start there in terms of, because I think that's going to guide the structure of this opinion going forward. And would love to hear from you about what you think about whether to include or exclude hypotheticals and anything in between for this opinion.
Justin, I think it reads really well, and I think the question it's addressing lends itself well to the format of not having hypotheticals. That's just my reaction.
I agree with that too, Elizabeth.
Any different views on that, whether hypotheticals would be helpful here, or if you're in agreement with Brandon and Elizabeth?
I just can't. I mean, I generally agree that I don't know that we need the hypotheticals. I'm curious though, we cite those 4 other bar opinion. Did those have hypotheticals, or how did they deal with it? I haven't read them.
Let's see. I don't know if I have them in my COPRAC file here. My general recollection is that some did and some didn't. But that may also have been driven by how those state bars issue opinions. I don't have it in front of me, unfortunately.
Yeah, I was just, I mean, it seems the way the format we have it now covers all the various issues without tying them to a particular hypothetical, which could just kind of confuse things. So
I agree that it lends itself to not having hypotheticals, and kind of what Sarah had mentioned in the last opinion about sometimes when you have hypos, then you can get confused and be having to like scroll back and figure out what was the difference between this and this. And unless we really want to draw attention to a particular difference, then I wouldn't add it just for the sake of adding.
Yeah, I agree with not having hypotheticals for this draft. And I think a lot of it reads well, and it's just a lot of generally applicable concepts. So I think it makes sense not to have hypotheticals.
Justin, I'm not sure if you saw, I sent you, Ohio issued an opinion on August 5th, 2022. I can circulate it. It was right around the time of our last meeting, but I was like really sick with COVID and was barely functioning. So I don't know how I managed to send it to you, but I just checked my email to make sure. So I have it handy if that would be helpful.
Yeah, I did receive your email. Thank you. And
I don't know if it's something that you want to reference here too or not, but I just
yeah,
wanted
I
to make sure.
agree. I 100% agree that we'll want to add that to this opinion. I think there hasn't been an update since.
Okay, great. It's the most kind of hot off the press.
Right. Yeah, I think we definitely need to take a closer look at that opinion and see, what one thing that I think we're trying to do here is see where we agree and disagree with prior opinions on cryptocurrency. I think there are some differences that we have with some of the prior opinions. And so I think we need to do the same exercise with the Ohio opinion and see, because I think being able to point out those types of similarities and differences and conclusions based on our own rules and precedent is helpful to California practitioners. So 100% with you. I'll be flagging for Elizabeth and Bill that we need to take a close look at that Ohio opinion for those reasons. So yeah, thank you for sending that.
Mhm.
While we're on that section, I had a stylistic observation on, I guess it's the prior page, line 83. Starting there. In number 3, we talk about the North Carolina bar opinion and how it differs from the DC one, which then followed. I'm just going to suggest flip-flopping them. If discuss the DC bar opinion first and then the North Carolina bar opinion, which disagrees with it.
Yeah. That makes sense. I think this, and I think we have a good consensus here on continuing to draft this without hypos. So why don't we focus on this was another point that I wanted to discuss. This section regarding other ethics opinions. I think that we want to retool this a little bit, including what Ken suggested, reordering in a manner that will be more helpful to the reader. I'm just not sure that bullet pointing all of the prior opinions is going to facilitate what we're trying to do, which is to not be overly repetitive and kind of get to the point of here are the conclusions that we reach based on California rules, and to some extent, other ethics opinions. I'm not really sure how this will be retooled, but I'd prefer it not to be just a list of prior opinions, and I don't have a good solution for that, but I think this is something we want to retool a bit.
Yeah, Justin, on that point, I think, I don't know, maybe it's just, haven't read all of them, but I think it's not as common to have a whole section that just is addressing other state bar ethics opinions. And it might be more useful to incorporate below as part of COPRAC's analysis, some of the opinions, particularly the portions that we agree with, or put them, I don't know, devoting a whole section to the other bar association ethics opinions. I'm not sure if we need that. I think it might be better to incorporate into our analysis.
Yeah, we do a lot of opinions that just say other states have, viewed it from this point of view or this point of view, and we just sort of summarize, but it doesn't sort of highlight them the same way.
Yeah, those are great. Those are great organizational suggestions. I completely agree with you, Sarah and Brandon. So my plan is these are helpful notes that Angela or Mimi is incorporating here, and then I will sort of annotate those and provide them to Eleanor and Bill, because I agree. I think that these are good ways to address the other opinions in maybe a more helpful way, rather than just having a laundry list of prior opinions, because we don't usually do that. I agree.
This is Cassidy. One thing, if there's a, I think there is some utility with discussing the other state bar opinions in some fashion, because this is such a, hot button issue, and there's, the opinions may be all over the map, but I think I would put it at the end in a, not in a bullet point, but at the end of the opinion, to say, this is what other states are doing with this issue.
Yeah, well, I agree. We want to be a resource for the reader, and so it's at some point in our opinion, we'll want to and make sure that we've cited to all of the cryptocurrency opinions that we're aware of. So whether that's built in or in some kind of footnote where all of them are in one place, and we can say that others have weighed in on this. See da 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 da. I think I agree. We want that in some kind of clear fashion for the reader, so that they can go and use the table or the footnote or wherever it is as a resource, in addition to what Brandon and Sarah are talking about, which is where we differ on a material point with some other ethics opinion, highlighting that at the same time in the body of the opinion. So I think these are compatible suggestions, and we should do them all. Any other either conceptual or more specific substantive comments that you have that we should relay to Eleanor and Bill for their drafting at this point? So another thought, since we just got to the applicable rules section, I also felt similar to what we discussed in the opinions of other state bar section, that here we're kind of just listing out the rules for several pages, and they're not necessarily tied to cryptocurrency. And so I don't think it's, I think that this should also be massaged in a way where we're tying the rules either to cryptocurrency or building in our discussion of the rules to the discussion with the discussion of cryptocurrency, because it also feels a little bit like a laundry list at this stage. And so I think we want to refine that in a similar manner to the state, how we're going to redraft the discussion of other state bar opinions. So on the one hand, we want to highlight the important rules or implicated rules of professional conduct, but on the other hand, we don't want to just have a copy paste section of what those rules are. Does that make sense?
Yes.
All right. Anything else? Questions, comments, things we should pass along to Eleanor and Bill at this point? Well, if something comes to mind, we have time to come back to this opinion. So, just shout out if you have additional thoughts, or send an email to Eleanor and Bill. I'm sure they welcome any feedback that we have. So we're just chugging along here. I'm thinking we start the discussion of changes to the rules of professional conduct. If would this be Sarah or leading this discussion, or is someone else taking the lead on that? Sorry, you're muted.
I said I'm happy to take the lead, and Cassidy is also on the subcommittee as well. I don't really see anyone else who participated in our last subcommittee meeting. I think Hunter and Bill. Cassidy, am I missing someone?
Toby?
Toby, sorry, Toby's here too.
Toby.
Toby. So Cassidy and Toby, I think will contribute, but I can start with just going over the key changes from our last subcommittee meeting where Toby and Cassidy both participated. And second, sorry. And Erica, thank you very much for what you prepared for our subcommittee. It was very useful in kind of highlighting the changes that COPRAC is recommending the Civility Task Force revisions. I know what we produced for the last meeting was confusing and difficult to follow, but thanks to the new format and what you prepared, it was very helpful to kind of highlight what changes COPRAC is recommending. So as you can see here, what we're showing in red line are COPRAC's recommended amendments to the Civility Task Force amendments. So our additions are shown in green highlighted, and deletions are in strike through. So here for the just definition section, Rule 1.0.1, the Civility Task Force added a definition of incivility, And at both the COPRAC larger group meeting and the subcommittee meeting, we discussed that we believe the term other significantly unprofessional conduct, which we propose to strike at the end, is too vague to be a disciplinary standard and could implicate First Amendment concerns. So as a result, we propose to strike that and instead define incivility to mean significantly unprofessional conduct that is discourteous, abusive, or harassing. We think that is more appropriate to have a clearer definition for a disciplinary standard. And then the other change that our subcommittee recommended, and also I think we discussed it at the larger meeting, is the addition of comment 4, which is in green highlighting below. And again, this is just further clarifying that, I'll wait till we get there actually, that the definition of incivility is not intended to apply to protected First Amendment activities. So those are the changes made that we're recommending be made to the Civility Task Force's proposed amendments to this rule to address incivility. And the other thing that this comment addresses that I didn't highlight is the definition also includes conduct that violates an attorney's duties under State Bar Act, 6068 subdivisions B and F. So if you scroll down to I don't know if everyone had a chance to read this in advance for our meeting, but if you scroll down to the very kind of end of this rule, we added a section COPRAC subcommittee comments just to explain this. This is the format we followed for each of the rules to explain our analysis about why we are recommending the changes. And I already went over that, but just for your review, I wanted to explain how this format is. So before moving on to the next rule, I want to see if Cassidy or Toby have anything else they wanted to add on this rule and our proposed revisions, or if others also have any concerns about the proposed revisions.
I don't. I think that this is clear and it covers what we discussed in our subcommittee meeting.
Before we go forward, just to kind of set the stage for the committee in terms of how we envision using this work product, is the subcommittee's kind of thought that we would use this format as what we submit in terms of our feedback to the proposed civility rules, and then basically have the committee as a whole vote on it, and then basically where it says COPRAC subcommittee comments, it would become the COPRAC comments. Is that kind of what we're envisioning?
That's my thought, yes.
Okay, all right. And then related to that, maybe Erica or Randall, if you have input on this, what is the current timeline for which these comments would be requested of us? Is it, I thought it was sometime in the fall. And what I'm wondering is if we have another meeting in October to vote this out, or whether, given the timing, we would need to vote this out today.
So as far as timing, you do not necessarily have to vote it out today, although it could be helpful depending upon how the discussion goes today. It is planned to be presented at not the next Board of Trustees meeting, which is later this month, but ideally by the November board meeting. And let me pull up the exact date on that. Bear with me for just one moment here. So it's November 17th and 18th, and our next COPRAC meeting is October 14th. So that would be sufficient as well. So if there's more time needed for the next discussion at the October 14th meeting, that should be enough time.
Okay, thanks. So, I mean, let's see how it goes today. And then we can decide whether we need more time or want more time to work on it further, I guess.
Yeah, and I don't necessarily have a strong opinion one way or the other. I do note that a couple of members of the subcommittee unfortunately couldn't make it today, so perhaps it might make sense to wait. But at the same time, I do know that we had a meeting and we kind of all agreed on already these comments. So I think we already have a consensus among the subcommittee members at least. So yeah.
Who's not here that's on the subcommittee besides Hunter
And Bill.
and Bill? Okay. All right.
And then, okay. So I will go on to the next rule, which is 1.2, the scope of representation and allocation of authority. So our Civility Task Force recommended adding what you can see has that our subcommittee recommends striking language to the substance of Rule 1.2 that states a lawyer does not violate this rule by acceding to requests of opposing counsel that do not prejudice the rights of the client, being punctual and fulfilling all professional commitments, avoiding offensive tactics, and treating with courtesy and consideration all persons involved in the legal process. We felt that this wasn't appropriate to include in a disciplinary rule, that it's more of an guidance and an example. So we recommend moving this to a comment and also revising it slightly. So if you could just scroll down a little, yeah, in comment 1, we address this, and this was based on some of the feedback from our last COPRAC meeting too, where I think there were people who seemed to like the language does not violate this rule by, and also comments suggested tying it more to the language of this rule 1.2. So that's why the comment, which is basically removing what was previously in the rule to the comment, it's also been revised to make a clearer connection to the rule, where in here it's just talking about the scope of the lawyer's authority. And the allocation of the authority between the lawyer and the client. So we're saying, for example, this is following what a lawyer is authorized to act on behalf of the clients. This is procedural matters and making certain tactical decisions. And so here we said, for example, a lawyer is authorized to accede to reasonable requests rather than a lawyer does not violate this rule by. So that was the change to the language that was originally language of the Civility Task Force. And the remaining portion is consistent with what the Civility Task Force recommended, other than it's been moved from the rule to the comment. Oh, and one other thing, I guess it's hard because it's not really showing clearly, but the other change that the subcommittee recommended, and I think we also discussed that at the larger COPRAC meeting, is adding reasonable before requests. That wasn't part of the original Civility Task Force recommendation, so acceding to reasonable requests of opposing counsel. And then finally, I think there was one other change, and it's all in green highlighting now. The reason I'm sorry, it's hard to follow us a little bit because we moved it from the rule to the comment, so that's why we're showing it all in green highlighting. But as a result of doing that, it's not capturing precisely our changes. So we also did the language dignity, courtesy, and integrity has been added. I forget if you could scroll back up. I think previously it said, oh yeah, treating with courtesy and consideration was the language proposed by the Civility Task Force. And rather than that language, we use language that's consistent with the Civility Rule 9.7 from the California Rules of Court, which is, I'm forgetting because I don't have it in front of me, but if you scroll down below, it's treating persons involved in the legal process with dignity, courtesy, and integrity, because just as there's already a standard that's been developed under the California Rules of Court, we thought we should be consistent. So I think that summarizes the proposals that the subcommittee and larger committee made to the Civility Task Force's proposed revisions to Rule 1.2 to address attorney civility. I'll see if others have any feedback that they would like to share or concerns about the revisions. Okay. I'm not hearing any, and I think this might be because we did go over some of these already at 2 meetings. You know, we discussed the rules. So I think at this stage, at least I'm hoping we're somewhat aligned in some of the revisions we're suggesting here. I'm going to move on to Rule 1.3, the changes that COPRAC and the subcommittee is recommending. And this, the comment previously read, a lawyer's duty to act with reasonable diligence does not eliminate a lawyer's other professional obligations, and lawyers should strive to treat all persons involved in the legal process with dignity, courtesy, and I'm not reading it correctly, and integrity. But anyway, we recommended striking some of the language that we found problematic, which is the language strive to seek, that we felt that was very vague and subjective. We didn't understand what that meant. So we thought we should just be more straightforward and direct and simplify it by just saying should treat all persons involved in the legal process. And again, the other change made is just consistent with what I said in connection with 1.2, which using parallel language to the already established civility rule, California Rule of Court 9.7, dignity, courtesy, and integrity. And the other changes here were made just to kind of simplify the comment.
Just a question, Sarah, because we didn't see the comments at the bottom of the last one. Is this one? Is the parallelism called out, the parallel language called out in the comment at the bottom on why COPRAC made the changes? The parallel
the parallel language comment. Yeah, it's down here. And I'm wondering, I would say 9.7. Is it 9.7 or 9.4 now? I might have been misspeaking. Which is this? Someone tell me which is civility, the California Rule of Court. Is it 9.4 or 9.7? I'm forgetting now because I just realized I was saying 9.7 and I forget if it's 9.4.
You're correct. It's 9.7. It was renumbered from 9.4.
Okay, so maybe we should change it to 9.7 here. And I wonder if we use the wrong reference up above too.
Yeah, okay. I just wanted to confirm it was there because I think it's important.
Yeah, and if we could scroll back to 1.2 to make sure it's there as well, and also to make sure we're referencing the right rule. I think we are here, but I guess we just had an old reference. Let's see. Yeah, okay, so we are, okay, it's correct. Does anyone else have any thoughts on Rule 1.3? Okay. So I'm going to go on to Rule 3.3. I think it's subsection E, which during the subcommittee meeting, and I think this is also discussed in a larger COPRAC meeting, I think the members had concerns that the language of subsection E was broad and somewhat vague and unclear, and we were trying to streamline it, and we thought some of the language was more appropriate to include in a comment than a disciplinary rule. So the proposed revisions are to strike basically subsections 1 and 2, talking about a pattern of incivility, which I'll discuss a little bit more, and Cassie can probably chime in on that as well, because I know she was discussing this during the subcommittee meeting that at the last COPRAC meeting, I think there were concerns with that particular language. And then intentionally or habitually violate any established rule, procedure, or evidence, that was stricken. And so it's basically limited to engage conduct solely intended to disrupt the tribunal. So COPRAC is recommending the addition of solely to clarify that it doesn't apply to permissible activities that would be consistent with an attorney's duty of zealous advocacy. And then if you scroll down to the the comment, you'll see that we moved some of the language from subsection E to the comment, and I don't remember what comment it is. Let's see. Oh, comment 10. So I think if you could scroll down a little bit more, because footnotes 2 just address some of the concerns. There were concerns about at the last meeting, I understand, about the term habitually. And this was Hunter's comment, who unfortunately isn't here today, but potentially that being misconstrued given the precise meaning in criminal context. And we talked about it at our last subcommittee meeting, replacing that with another term such as severe or habitual or repeated. Also, we considered pervasive in place of habitual to track established language used in employment law cases. But overall, there were just concerns about the language that's in this comment. And is it, even though we did move it from the rule to the comment, I think there are still some concerns that the language is just not clear. So if there's better language that we should be using, we welcome feedback on that issue. So if you could scroll back up so we can look at the language again to comment 10. I think we might want to consider further revising this comment, given concerns about the language habitually engaging in incivility. Is there a better way to phrase that? What do folks think about that?
I think repeated or repeatedly is probably better than habitually. I don't recall if habitually is a term of art in criminal cases that Hunter was talking about. I know patterned was, and we're not using that here. I think we struck that. So I can't recall what issue we had with habitually in that context, but I think I just like repeated better. And then we were we did talk about, there's still an issue of, a single incident that's so severe that could, rise to the level of a violation. And I don't know if that's taken care of by, or intentionally violating established rules of procedure or evidence. I don't think that comes through there, where it's, something that's just so outrageous that, it happening once is enough.
Yeah, and Cassie, that's helpful, because that's what we discussed in our subcommittee meeting. I forgot to raise that particular issue.
Could it?
That makes sense, but I don't think that it's addressed like an isolated incident by or intentionally violating established rules of procedure or evidence.
Could it say, or an intentional violation of established rules of procedure or evidence?
Well, isn't that what that says? Wait, I'm confused.
No, you said, I thought your issue was that if there was one egregious violation.
Right.
So if you say, or an intentional violation or an intentional egregious violation of established rules of procedure or evidence, as opposed to or intentionally violating.
Yeah, well, sorry, go ahead, Sam.
No, go ahead, Cassidy. I'm sorry.
Well, is an outrageous, act of incivility also, it doesn't necessarily mean you're violating an established rule of procedure or evidence.
All right.
You could, be screaming in court like a lunatic. But I don't know if that necessarily violates a rule of procedure or evidence.
Yeah.
I don't know why that's, what's an example of intent? It's just something that, you're intentionally violating a rule of procedure or evidence just to be, for no reason other than to be a jerk. I don't know what that means.
Yeah, and I'm wondering if that really adds much value,
right,
to this disciplinary rule and comment. I'm actually questioning whether we should keep it based on the discussion we're having.
Right.
But I do think we should consider whether, maybe it needs to be reworded so that the first part, prohibition paragraph E applies to, maybe it could be worded like engaging in repeated or egregious or repeated or severe incivility. I'm not saying I'm probably
Sarah,
not, but something to address the isolated incident that is just so severe.
Sarah, on that point, could we back up to the word solely up in the way you modified it? I'm imagining cross-examining a witness. I have a right to cross-examine that witness, but I do it like a total jerk, screaming and yelling. I'm not doing it solely for an improper purpose. I've got a proper purpose. So when you talk about how many times you have to do it or how egregious it has to do, I think you've also got to go back and look at what solely means.
We had a reason for that. Wait, go back. Can you go scroll up to solely? We really did Hunter, we discussed this during both meetings, I think, subcommittee meetings, right? Well, no, then it's, in appearing as a lawyer before a tribunal shall not engage in conduct solely intended to disrupt the tribunal. So in your example, you are legitimately, okay, so so you've got two purposes. One is to cross-examine, the other one is to be a jerk, and you shouldn't get a free pass to be a jerk. And so it's not solely, yeah. Why did we think this was okay? Right.
Yeah.
Well, the rule itself is candor toward the tribunal, right? So this is sort of a non-answer answer, more of a comment about this addition of E. It's already kind of, to me, a bit of a stretch to include it in a rule that's supposedly about candor toward the tribunal. How you cross-examine a witness, I guess maybe this is how I'll try to respond to Joel's comment. How you cross-examine a witness is not about whether you're being candid to the tribunal. So arguably it's outside the scope of what this rule is intended to encompass. Rather, at least as if this is really about the interaction with the tribunal, 3.3E is getting at something other than examining a witness, but more about the actual interaction with the court or the tribunal in some manner. So maybe the hypothetical, while concerning, wouldn't necessarily be covered by 3.3E. I think that is then what I'm saying is maybe supported with the comment 10, the last couple sentences that are talking about it's not a rule violation to stand firm before the tribunal for your client and things like that. So maybe we don't have to worry about the concern of that hypothetical here, at least.
And Justin, the other, you made a good point, and we also did discuss this at our subcommittee meetings, and that, a lot of this stuff, does it really belong here at all, this edition, as part of Rule 3.3 that is dealing with candor towards the tribunal? Because we also, at one point, I talked about just moving a lot of the stuff to Rule, I think it's 8.4 down below, which we're going to get to. Which seems that deals with misconduct, and this seems more appropriate as I'm, evaluating further to have there. And I know we talked about that at the subcommittee, and I think one of the larger group committee meetings as well. So I'd like to have people's feedback, but I don't know. I'm questioning whether it really fits here. It doesn't seem to fall within the scope. I'm questioning if we should just recommend that we don't adopt the task force's recommendations to Rule 3.3 and instead incorporate some of the language to rule 8.4, either the substance or the comments of that rule.
And that was my thought as well. I mean, it's civility is not a candor issue. I mean, I always question whether that really belongs in that location. So I think move 8.4 probably is a better place to address it.
Yeah, I agree with that.
So maybe what we're proposing here is twofold. One is to add to our comment about the addition or revision that we have concerns about it not being appropriately placed under Rule 3.3. And then, secondarily, but if the powers that be want to put an addition here as 3.3, here are our proposals. Here's how we would revise what you've given us to consider.
That makes sense. And could you scroll back down to the comment again here? Okay. Could you scroll down a little bit further? I'm just trying to see if we address. Oh yeah, so we did have that here. What's highlighted in yellow here, what I just went over is there's also general discussion regarding whether proposed amendments, so not just 3.3, but the ones we're going to get to, should all be moved to 8.4. Okay.
And these are going to go out for public comment too, right? I can imagine that there would be there would be a significant public comment about like how confusing that is. Why is there civility, rules in the duty of candor? Because it doesn't make sense, really.
Yeah. Okay, so I think we should probably, and I think we can do this before our next meeting, just work on revising our recommendation here to start with our first recommendation, which is really just to not adopt this rule and instead incorporate it as part of 8.4. And then as Justin said, explaining it, if it nonetheless is part of the rule, changes we would recommend. So were there any other thoughts on Rule 3.3?
I don't know if this, I'm just having a flashback to my my soccer refereeing days, where I don't know if any of you are soccer fans, but the handling of the ball offense, hits the hand and a penalty is called. It's a long debated rule, and when it should be called and what was the intent of the defender when it hits their hand, and not even the best referees in the world get it right. And so I see this word intent, and it just has a special significance to me because intent is so hard to evaluate. And I do see a distinction in the rules of professional conduct where, like with 3.3a, it does talk about knowing. And intent is to me is a little bit more nebulous. And I just wonder this concept that we're grafting into candor towards the tribunal, that there's a discipline rule if you solely intend to disrupt the tribunal. To me, I worry about the nebulous nature of that word intent, and I don't offhand remember how it comes up in other rules. But maybe we can just do a double check to see how the use of the word intent or intended shows up as distinguished from knowingly in the rules, and if there's something to be said in our comment about, this isn't used in this context in the rules. This would be a game changer or something along those lines. We might want to flag that concern for this formulation as well. So that's it.
So Justin, what are you saying? If somebody is just naturally a jerk and doesn't intend to be, that gets a pass? I mean,
I don't know. Well, I don't know, and I don't know what they intend
you're
here.
right.
by
We got
this
to define
language.
that somehow, because sometimes you mention the the handball, the handling, sometimes if it has the effect of controlling the flight of the ball, that can be the penalty. So even if you didn't intend to do it, but you just weren't careful about where you had your hand.
Right.
So,
And so what do they mean here? You know, how should this
Yeah.
be interpreted? You know, I look at, again, my soccer analogy. Nobody is consistent. Well, here we're talking about discipline rules where folks can lose their license. So I think we want to make sure that, unlike the soccer rules, we have something that can be consistently implemented. And so that was my concern about the formulation here, that I think it's worth a double check to see how it's used elsewhere in the rules, to see if there's a
You're not suggesting that disciplinary rules are more important than soccer outcomes, are you?
Of course, no.
Okay, good.
No.
Nothing's more important than soccer, but anyway.
Yeah.
And Justin, just on that point you're making too, which I think is a good one. I mean, the rules, the purpose of the rules section, what 1.0 that discusses the purpose of the rules, rule 1.0 talks about, you know, intent. You know, and they say that, you know, a willful, you know, it's required that there be a willful violation of a rule for disciplinary standards to apply, and that, but a willful violation does not require the lawyer intend to violate the rule. And there are examples of this in some of the state bar cases. So I think the analysis that we consider at our further subcommittee should also consider rule 1.0 and what willful violation of a rule means.
Yeah, agreed.
As long as we're on the subject, I think it should also be noted, I believe Joel's a member of the National Soccer Hall of Fame, so.
You said Joel's a member of the National Soccer Hall of Fame?
I believe so.
Really?
That's true. That's true. I was inducted in 2008, but not for my refereeing, Justin.
You were a player?
No, I was an organizer. I was a national president of AYSO.
Oh.
So.
Oh, you're that Joel Mark. Okay, well, we'll talk later. We'll talk later. Gotcha. All right. Sorry, everyone. So should we go to 3.4?
Sure. Again, this was actually, I'm sorry, just for, as we're evaluating this, could you scroll? I just want to see 3.4 is addressing fairness to opposing party and counsel. Okay, so 3.4, I guess the proposed revision is at subsection F. We revised that to say a lawyer should not ask any question solely intended to degrade a witness or other person. And I think the reason for attending solely here is a little clearer.
Yeah.
Where we were trying to avoid any kind of questioning that is really done for impeachment, you know, that is permissible. And so, yes, it will degrade the witness, but it's, you know, it's really for impeachment to question the credibility of a witness. So we thought it was appropriate to add solely here. And because you're adding solely, we felt that the following language, except for the lawyer reasonably believes that the question will lead to relevant and admissible evidence, that was unnecessary. And just further analyzing that too, you know, there could be a question of, well, why do we need solely? Why couldn't we have left it as is with that language? And I think we feel that the language except where the question will lead to relevant and admissible evidence is too narrow, because impeachment is not necessarily always going to result in admissible evidence, and will lead to relevant and admissible evidence isn't even the standard in the Code of Civil Procedure. It's broader, the scope of relevant discovery, likely lead or is reasonably likely to lead, I think is the language. So we thought we were addressing a disciplinary standard, you know, using solely here makes sense to just clarify that it doesn't, this rule is not intended to prohibit conduct that is permissible in the litigation context, such as impeachment.
So there's that word intend again.
Yeah.
So this is going to be a difficult one as well. Yeah. I mean, is there an alternative? Is there an alternative? You know, because really it goes to, you know, why are you asking the question?
Yeah.
And maybe it's that has no other purpose other than to degrade a witness or other person. But I guess that's just another way of saying intended.
Yeah, I mean, I don't know, maybe there's a way to incorporate the use of the word knowingly there. I mean, that will, while also incorporating this solely, like if you know that the only, I don't know, I'm just thinking out loud, like, and again, I don't know how big of a deal the use of the word intended is going to be. I haven't done a word search, but
It seems to me that you could ask, you could just delete intended and leave in solely, and it works.
Oh,
Question solely to degrade, and then use the comment, and you don't need intended there.
I mean, it's implied.
A lawyer should not ask any question solely to degrade a witness or other person.
So how do you prove that?
Or-
How do you prove that without, you know, going into the lawyer's state of mind and intent?
Or solely in order to.
Yeah, I mean, it's the purpose. What's the purpose of the question?
Yeah.
Yeah. But you know, you necessarily have to get into intent, you know, if you're going to make this a violation.
Yeah.
Yeah, and I think that's the main concern, is just the difficulty in enforcing this type of rule as a disciplinary standard.
I mean, on the one hand, we want to, you know, that's the whole, like the, you know, fundamental reason why they're proposing these rules is because there needs to be some sort of recourse, you know, or some sort of consequence.
Doesn't,
But is it?
I'm sorry, Sarah.
No, it's
I was
okay.
just thinking, it just came to me that, doesn't the rule on competence talk about repeatedly or recklessly? I think, which is kind of what we're trying to capture with intended, I think. I'd have to look that up, but that's my recollection. Repeatedly or recklessly.
It also uses intentionally, so.
Oh, it does. Yeah, it does. It's recklessly with gross negligence, shall not intentionally, recklessly with gross negligence or repeatedly fail to perform legal services with competence.
So if that's the standard that we've been using for competence, I don't know why something similar wouldn't be appropriate in talking about civility.
That's a good point. Yeah.
Yeah.
Could you just maybe add, I'm not sure, Mimi, if it's you or Angela, but that point here, just that intentionally is used in the duty of competence rule.
I think the problem here, though, is that when you're talking about competence, you're dealing, you know, you're talking about, you know, how you are handling a client, you know, how you're treating your client, you know, how you're handling your competence towards the client. But here you've got competing interests, you know, where you are required to act zealously on behalf of your client, and you may be, you know, coarse in your delivery, and you may, you know, there's a gray area there on the
Well, no,
intent issue.
I think when you're talking about that rule, that language in the competence, you're talking about frequency and severity of the conduct, not to whom it's directed. Even though the rule is directed to the client, and that phrase just talks about frequency and severity of what gets you in trouble.
Yeah. I don't know, I just keep going back to Justin's comment of, this is putting somebody's license on the line. And for trial conduct. And I don't know what I agree with.
Trial conduct that's not directed at the client.
Right.
Presumably, right.
Just on that topic of the trial conduct, that's distinct because there's a judge in the courtroom who's supposed to control events. And if some attorney is way out of line, they could be threatened with contempt or other things. It's just maybe not, there's a lot of instances where the only thing governing the conduct is the rule of professional conduct. But when you've got a judge in the room, it's a little different.
That's a great point. I mean, it also counsels against needing a rule of discipline when you have a judge who's there to weigh in and protect the witness or, the conduct of the courtroom. Why is it that look, I guess the devil's advocate, which I might agree with, is that a rule of discipline will reinforce positive behavior in the courtroom so that a judge doesn't have to rely on his or her own personality and laying down the law to encourage proper behavior. But I do think that is an important overlay to consider here in terms of how we choose to word the language here for F.
The other thing is just to keep in mind that this isn't intended to be limited to trial situations here, though. This could apply at a deposition, for instance.
All right, we're talking about fairness to opposing parties.
Yeah.
I mean, can you, I don't know, I can see some abuse of this by opposing counsel, filing complaints anytime. But, at the same time, that's what the purpose is. They should be able to file a complaint when opposing counsel is being a jerk.
Yeah, I mean, and just something as I'm edit finding here, the word intentionally, we talked about competence. It also shows up in diligence. And those are really the two places in a quick word search that I'm seeing intentional come up in analogous ways. But I would say that Cassidy made the point, it's not, we have to think about whether it's really analogous, because the competence is really about how you perform your legal services, which is about really how you're representing your client. And diligence is also specifically in 1.3a about how you're representing your client. And it's just, it feels different than what we're talking about here, which is being mean to a third party. And so anyway, I'm just wanted to flag that usage as I saw it in the rules.
Well, I don't know how far afield it is, because whether I'm in court or in a deposition or doing anything else, I'm also representing a client. So that's why I think that as a phrase which talks about, as opposed to intended, it would oppose to the kind of frequency and egregiousness of what you're doing, how far that would have to go to get you into trouble. I think it's pretty good, even though it's not directed to a client, it's directed to somebody else. It just shows that's a line that now you've crossed in conduct. I did it repeatedly. I did it recklessly. I did it, to hurt somebody, whatever. That phrase seems applicable to me, whether or not it's, in addition to just being for a client, it's for anybody to get me in trouble if I do that.
Well, just to pull a 180 on my concern about the use of intent, one could argue that using intent here or intended in F creates a higher standard than what you see in, say, 1.1 or 1.3, which also includes reckless or gross negligence. I think intentional is a higher standard, at least in my mind.
Yeah.
And so this, one could argue that using intended to degrade as opposed to acting in a reckless manner, which might degrade someone, is a higher bar for discipline. So, boy, you can argue both. I'm arguing both sides here, and that kind of concerns me that you can kind of see concerns on both ends when you're trying to create a discipline rule that can be clearly and consistently interpreted. So I know I'm not answering questions here, but I'm certainly sorry to raise them.
Yeah, I would add, it's not just limited to questions. If you're going down that road, I mean, what about allegations in a complaint? I've seen many complaints with allegations that are, I guess they're subject to a motion to strike because they're superfluous, but they're in there, for no particular reason other than to degrade the opposing party. It's an unfair allegation. I don't know. This doesn't really address that issue, but it's once we start going down that road, I think it opens up a bit of a Pandora's box. And you've got litigation privilege, I guess, might apply on a pleading, but.
Does a litigation privilege apply in disciplinary matters? I don't think it does.
Yeah, I don't know the answer to that one.
I should know the answer to that one.
A great question, actually.
I feel like I've looked that up before and I can't remember really what the answer is. Well, on that same line though, why are we, this is kind of, why is it limited to ask a question too? I mean, maybe this whole, I think I think this whole thing probably does need to be reworded because I may have issues with ask any question. I mean, what if you're just treating the witness poorly and you're not actually asking a question in the deposition?
That's a great point. I mean, people make statements and just do all sorts of rude things, and we seem to be limiting ourselves needlessly.
Yeah.
If we're trying to rein in abusive conduct, it's not just in the form of questions. Yeah, great point.
And then degrade. What is degrade? I mean,
Now, Cassidy, I just looked up degrade, and degrade seems to work if you look at the very definition. But you're right about the question. I recall one time when somebody called as a witness the crook from Pasadena, so hadn't asked a question yet.
Yeah,
So,
I mean,
and also, I don't know, we're struggling with something that, even one Supreme Court justice has said about pornography. I know it when I see it. I mean, we kind of know it when we see it, but capturing it in exact words is tough.
yeah, that's been kind of my problem with this whole thing. Although I do think it's necessary, it's just hard. It's just difficult to figure out the way to do it.
Yeah. I'm trying to think of if there's ways we can revise it so it's not as narrow as both Ken and Cassidy you're saying in terms of it shouldn't be limited to asking a question. So I'm just
Yeah, I mean, should ask a question or make a statement or I don't know if you want to say or throw an allegation, but if the whole point of the comment is solely to degrade the witness or other person.
yeah, I like that revision. Should we redline it here on the spot? A lawyer shall not make a statement in place of ask any question.
Shall not make a statement or ask any
Yeah,
question.
I think
I think both.
That works. Yeah.
We could we say engage in conduct, or is that getting too?
Yeah, I was thinking that too. Engage in conduct.
Shall not engage in conduct.
Or mannerisms. I mean,
Wouldn't that be too broad wouldn't that be too broad for a disciplinary rule, engaging conduct, and then everybody will say what
Right.
conduct?
well, yeah, I mean, making a statement can be nonverbal and, that's been established in other areas of the law. So, I think we've captured it by saying a lawyer shall not make any statement or ask any question.
Do we need to tie this to some kind of legal representation? Because I don't think we're saying, as it reads, one could read it to mean you degrade somebody as a lawyer, some other person, if you will, say at a soccer game to go there. That would be a rule violation. But I think we're talking about a lawyer degrading someone in the context of a legal representation.
What does it say in the introductory paragraph? Is it limited to? Oh, yeah, no, you're right. So there's no.
Well, it's opposing party and counsel, so that would seem to exclude the soccer game unless.
Well, I'm concerned about the other person reference. Other person is super vague.
Oh.
Oh, yeah, because that's intended to address a witness.
Party and counsel.
A witness, opposing party, or counsel, or something like that. I mean, just the phrase other person is what's hanging me up.
But as you say that too, Justin, as you're mentioning in connection with 3.3, that makes me question too, does this belong here where we're talking about fairness to opposing counsel and not
exactly
third party witness?
I think we at least flag it like we did with 3.3. We wonder if this is the right place. Who's in a rule that's, like you said, about opposing party and counsel, when you want a revision that's about other person, whoever that is, whatever context they mean, doesn't, it's not quite apples to apples at this point.
Yeah. One other point, and this was just going back, to make a statement or ask any question was what we talked about, and then I know I'm forgetting now. I think it was why am I not seeing him on the screen now? Brandon. I thought had said maybe engage in conduct instead, and I know Toby had some concerns with that being vague, but I think that language is used in other rules, like 8.4 it is engage in conduct, and I believe perhaps in other rules. So it is already established as part of the rules. So I don't think it's something that we couldn't necessarily use, we could decide to use here to kind of make it a little more concise, but I'm open to either. I just wanted to point that out, that engage in conduct is already part of Rule 8.4.
Does anybody know? Does anybody know why they want to kind of, if the civility is the issue, instead of just kind of intermixing it here and there throughout the rules, why not just create a whole new rule on civility?
Yeah, I like that.
I don't know if there's some reason why it's being done this way, or because it really seems like we're trying to put the square peg in the round hole, and instead of just addressing it head on and having a rule regarding civility, if that's what the powers that be want to have, make it a disciplinary issue, just have a rule on civility, and you could address all these various things in that rule.
And 8.4.
Yeah. And I do think, as we've been talking about, and Kathy just mentioned, I think 8.4, it does actually, to me, fit clearly within the context of 8.4. And that's how other states seem to have addressed it, is through Rule 8.4. And I think it makes the most sense there. I think trying to piecemeal incorporate, as Ken was talking about, throughout these other rules where it just doesn't really fit.
It sure seemed to be a lot cleaner and less subject to, hair splitting on what it means in this context versus that context.
It seems to me, I like the idea of having it in a separate rule, But to me, putting it all in 8.4 diminishes it. I mean, if there's a separate rule, I think that my vote would be, and I won't be here to vote on it, but a separate rule would be a rule related to, a new rule related to incivility. Because I think it gets lost in 8.4.
Randy, you have your hand up?
Yeah, just a quick comment. I think the idea of a standalone civility rule has a certain appeal. I think Andrew and I raised in our informal feedback to some of our former COPRAC representatives who worked on this project that we have noted in the comments received from Office of Enforcement, OCTC, that when the commission was engaged in rule revisions, there was concern about overlapping standards of misconduct, giving rise to problems of duplicitous charging for the exact same actions. And so I noted several times that the amendments being proposed were cross-referencing other rules, saying, well, this would also possibly violate this rule. Forcing the lawyer and OCTC to sort of jump around and see, well, which is the principal rule we should be charging in this instance. That could be obviated by having a standalone rule. At the same time, I do think the group that did this was trying to somewhat follow precedent of other jurisdictions. And so they were trying to say, well, we found this in this rule that this jurisdiction has, so let's follow their lead and put it here. But I've been noting the struggle of the square peg in a round hole, and I think there is a certain appeal to a standalone rule.
Does any state have an actual standalone rule rather than it being in 8.4? In other words, like rule whatever on civility? Do we know?
I don't know, but I do think the Civility Task Force report might have attached that kind of analysis of the other states' rules. So that might be a follow-up item for us to look into before the next meeting. Unless others know offhand. I don't think there is, but I don't recall.
Okay.
I think we've had a pretty meaty discussion of 3.4. Unless anyone feels we should push this one around more, maybe we move to 3.5 and see if we can get a couple more rules done before lunch.
There's only two left, so we might be able to tackle them. But 3.5 is a little simpler, our recommendation, that along the lines of what we've been saying with 3.3 to 3.4, we don't think this one, we just clearly thought did not fit within the scope of this rule, which is dealing with prohibited ex parte communications with the judge. And I'm trying, sorry, it's hard to see because I've only seen half the screen. Yeah, so I thought if you scroll back down, I think the concern was this addition: a lawyer shall not engage in a pattern of incivility that is degrading to a tribunal. It just didn't seem to really fit here, where the scope of the rule is dealing with really the procedure for engaging in ex parte communications with the judicial officer and the scope, and it just didn't seem to fit at all here. So we recommended taking this out altogether, where we just felt it was clearly out of place, and perhaps considering it in connection with Rule 8.4. So I don't think there's as much to discuss here. I mean, we've already gone over some of the language that we also thought was problematic, like pattern of incivility and what that means.
Yeah, I mean, I'm wondering out loud here, because I don't know offhand, but with 8.4D, engage in conduct that is prejudicial to the administration of justice. I mean, unless that's narrowly defined, wouldn't that include degrading the tribunal as prejudicial to justice administration? So, and if so, maybe we want to point out in the subcommittee or committee comment that, you know, our striking of the proposed 3.5C is not leaving a gap in the rules on this issue. It seems to us that it's encompassed, whether it's 8.4D, maybe somewhere else, to give some degree of comfort to those who are considering our edits, that you know, we're not just leaving a vacuum here, but that this issue is already covered elsewhere.
Yeah, agreed. And if you could go to our comments, I think we might have already, we talked about perhaps moving it to the comment to 8.4, which the comment is really, I believe, addressing what the scope of 8.4D and examples of incivility that could fall within 8.4D.
Yeah, it was in comment 6 under 8.4.
Yeah. And if you could just scroll down to our COPRAC subcommittee comments. Maybe we didn't already put it in there. Yeah. So here we could expand. This is where we could add that discussion here where we talk about moving it to the comments 8.4. So I see it's 12:08. I think, what time were we scheduled to stop for lunch, Justin? I don't recall.
12.
So should we, I mean, I think the 8.4 might require a little more discussion. I could try to get to it now, or do you want to wait till after the lunch hour?
We can wait until after lunch if you'd like, just in case it becomes extended. So 12:09, the lunch break we have scheduled is 12 to 1. I think that's plenty of time. I'm good starting up at 1 again, unless there was a strong feeling that you wanted to start up sooner than 1 o'clock. Okay. All right, so then let's come back, I guess, at 1 and finish 8.4 and just continue on with our agenda.
All right, sounds good.
And let me share my.
All right, so we left off at 8.4.
Sure. So as we were discussing before, this is where we moved a lot of the language from the other proposed revisions to rules 3.3 to 3.5 to go within a comment to 8.4, where we're discussing, and if you could just keep it on this rule first, where we're discussing kind of the meaning of 8.4D and that how that 8.4D could be applied to in civil conduct. So as you scroll, and ED is just engaging in conduct that is prejudicial to the administration of justice. And courts have applied this rule to address incivility. But if you scroll down, you'll see the comment we added. And so there was already a comment that the Civility Task Force recommended that we then revised and expanded to some extent based on our changes and to 3.3 to 3.5, where we thought some of the language from those rules was more appropriate in the comment to 8.4. So you'll see a lot of the same stuff that we went over previously here. Although again, there are concerns about the language that we haven't resolved yet, which is a lawyer violates paragraph D by habitually engaging in incivility while engaging in the practice of law and related professional activities. I think, I'm not sure if Cassidy is back yet, but I know that, oh, there you are. Sorry, I didn't see you on the screen. But Cassidy had recommended previously changing the word habitually to, I think, repeatedly was the word. So I think if we're going to do that, we should make the same change here from habitually to repeatedly, although that doesn't fully resolve the issue of an isolated incident, which I think we still need to address somehow. But I think the use of repeatedly is clearer than habitually here. And then, well, engaged in the practice of law. And again, this is addressing, Justin made this comment previously, you know, tying this to the engaging in, while you're engaging in the practice of law related professional activities. I know the term related professional activities was somewhat controversial in connection with Rule 8.4.1 dealing with discrimination, and but yet it was ultimately adopted, and so we're using similar language here, and it's also used in other jurisdictions. And then, or by intentionally violating established rules, procedure, or evidence. And here there is a cross-reference, and I know, you know, hopefully, I know Randy made the comment about the cross-reference here to other rules and the issue that presents for charging counsel, and it doesn't really, you know, if you are going to ultimately either, I know there are two suggestions. One, create a new civility rule rather than addressing it in piecemeal and other rules. But if you are going to, I think overall, it seems like the consensus is not to make the revisions to Rule 3.3 to 3.5. So if that's the case, we probably don't want to have we wouldn't have a cross-reference here then for a violation of a rule. 3.3E or 3.4F may also constitute a violation of paragraph D. It seems to make more sense to just have this all fall within a comment to 8.4D, which is kind of the rule that where it seems to fit the most. If we're going to have it as part of an existing rule, we talked about this a little bit during the subcommittee and committee meeting, it seems to fit most in 8.4D, which is dealing with misconduct generally that is prejudicial to the administration of justice. So I'll pause here to see what others feel. And I think getting a kind of a informal opinion of first whether you feel it's appropriate to have 3.3 to 3.5 be part of this comment, and separately whether it makes more sense to try to have a separate rule on incivility as opposed to incorporating this part of Rule 8.4.
I mean, I think that it seems like what we're doing is really diluting. If we're going to put it into the comment itself, move everything into a comment, there's no rule on incivility then, right? Is that what we're?
Yeah, I mean, there would just be the definition, basically. Yeah. And right. The other, you know, we didn't really discuss the 1.2. 1.2, I know that was just really the allocation of authority. I don't find that compelling of a change to, you know,
right,
efficiently address in civil conduct or incivility. So, although I don't think I thought the comment to 1.2 wasn't as questionable. You know, I think it did fit there pretty easily, but I am concerned over, yeah, I see what you're saying, Cassidy. You know, it doesn't seem to send a strong enough message perhaps to have it part of just a comment. And I think that was part of Toby's concern too, that she had raised.
Right. Right. I mean, what's the point of having even a definition for incivility if it's nowhere in any rule and only in a comment, you know? I don't know if there is a point. I don't know if that makes sense or not, but I mean, but I still think that it's fitting a round peg into a square peg into a round hole by trying to, force incivility into 3.3 to 3.5 when it doesn't exactly fit. But I think the compromise is to have an actual rule, a subpart of 8.4, right? And so, or expand D to specifically include, the prohibition of incivil and a prohibition against incivility. Or some, but that's where it would be. That's where the rule would be. And then this comment would expand on it. But that I think that would be my preference, is that, you know, I don't think it's enough to just have it in a comment to 8.4. I think it should be a separate rule, but I don't think it should be kind of peppered throughout the other rules that where it doesn't, you know, exactly make sense. Because I think that will just lead to confusion and abuse of the rule itself.
Yeah, Cassidy, what I was thinking over the lunch hour when I was looking at this is that I think in the earlier rules, 3.3 and all that, they're talking about a specific setting in a courtroom, in a witness or whatever. And I think it's good to have specific actions called out as being improper in and of themselves, whether it's civil or uncivil or whatever. You shouldn't do that. You shouldn't lie to a judge. You shouldn't. And then I thought, okay, let's put it all in 8.4. But then I was kind of taken aback by the heading. 8.4 is misconduct. And I read the things and I thought, wait a minute, misconduct is different from incivility. So then I came to the conclusion, as you just expressed, which was that maybe we need a rule following 8.4 in civility, where we put all these things which aren't related to the conduct, which is if you're going to be a lawyer, you're not going to be a jerk, and here's what you can't do.
Right. I mean, why can't we have an 8.4.2? We have an 8.4.1, you know? I mean, that makes the most sense, and that's how they dealt with discrimination. Yeah, I mean, I think that makes sense to me. Because it should be consistent with how they, do we have 8.4.1? What is that? I don't know.
Well, this, on the idea of a separate rule beyond 8.4, I guess, what I'm wondering is, do we agree that right now, 8.4D, engaging in conduct that is prejudicial to the administration of justice, as the rules presently stand, would that allow for discipline for someone who engages in repeated incivility, as that term is now being used in the proposed rules?
Well, that's the sea change. Are we saying that incivility or civility is an aspirational goal, or are we saying incivility is a disciplinary offense?
Well, so in the San Diego matter where the see you next Tuesday, the judge did refer the lawyer to the disciplinary for discipline based on 8.4D.
And just to clarify too, I mean, the purpose behind these revisions from the Civility Task Force is that having these like aspirational civility guidelines that many bar associations have, the state bar has, that's just hasn't been sufficient to address incivility. So the intent really is to create a disciplinary standard here. But the other thing that Justin raised about 8.4D, does that already address incivility? And I believe it does. And I'm not sure if I'm recalling correctly whether it's case law in California or if it's in other jurisdictions, but I do know that there's case law that has applied that same language that's in 8.4D to address lawyers' incivility.
Yeah, well, where does it say anywhere that then incivility is conduct which is prejudicial to the administration of justice?
Well, that's what we would be saying in the comment.
Okay.
Right? Yeah.
I think if you wanted to not have a separate rule, then you'd have to take 8.4D and put subparts to it where it incorporates, you have to put it in the rule and not in a comment. To make it clear that there are certain bounds of incivility that are not acceptable.
And including but not limited to?
No, I'm not saying including but not limited to, but if you're not going to have a separate rule to put it all in one place, then I believe rather than leaving it in a comment, which really diminishes or dilutes it, I agree with Cassidy, you have to put it under 8.4D, one or the other would be.
Right, but so then it would be a more expansive rule that talks about, you know, harassing a witness, except if you're impeaching them, you know what I mean? Like, are we gonna go through that level of detail of what is acceptable in civil conduct, you know, and what is not? I mean, it is
That's
difficult.
what happens when you take it out.
Yeah, no, I know. I mean, I think I feel like what we're getting at is, you know, going back to the drawing board and just really working on one rule that deals with all of this conduct that we want to address. You know, I mean, it's kind of, I think that's kind of where we're landing. And it has to be more thought out than, you know, redlining at this point.
Yeah, and you know, kind of big picture here, because probably October will be our last chance to discuss these things. I think it is for our task, at a minimum, maybe we can add to our committee comment section this struggle that we're having. We may not come up with a solution. Luckily, it's not an ethics opinion where we have to come up with a solution before it's published. But to flag these options that we've considered and the struggles that we've had with each option, or the, you know, the potential pitfalls of each option.
Yeah.
So for instance, having a separate rule related to incivility. Well, to me, that would be helpful and clear. But on the other hand, we already have 8.4D, which I think we would agree has been used and interpreted to already allow, you know, as a basis to punish those who are cited for misconduct related to civility. So having a separate rule might not quite work here. And it's nice to have this package in 8.4 about misconduct, which I guess on its face by the title is would include unprofessional conduct as well as misconduct, whatever, you know, to the extent there's any distinction there. Yeah, I don't know that we're going to reach a conclusion or a consensus here, but I think we can offer these options. So, you know, offering a sample comment, offering some kind of revision to 8.4D, offering a new maybe 8.4G, and letting them know in a couple sentences each, you know, here's, you know, we can't make the decision as to what's best. Here are the pros and cons of each that we've discussed. We haven't been able to reach a conclusion. Maybe we will in October. I don't think we're going to reach one today. But if we're still at that place in October, I think we say, look, we weren't able to reach a conclusion because we see the pros and cons of each, and, you know, go ahead and do what you think is best, the powers that be. So that's kind of how I could see this playing out when we get to October and have to vote on something.
I also like 8.4.2 as a separate rule.
No, I know. I'm not saying we shouldn't highlight that as an option. I'm just flagging in my own mind what I see as the potential downside to that, which is that we already have 8.4D, which is used to encompass incivility.
Yeah.
So then to have this new rule on it and it calls into question, well, then how should 8.4D be interpreted? And so, you know, that's one of the tensions that whoever has to make the final decision would have to grapple with.
Well, right. But I do like 8.4.1 could also be a violation of 8.4D. So, I mean, I don't think they're mutually exclusive. But yeah, I mean, in my mind, I think that, you know, we've got a discrimination rule, and then we can have an incivility rule, and the same conduct can violate all of, you know, D 8.4.1 and 8.4 in whatever incivility rule it is, right? Because you can, be harassing in a discriminatory fashion and violate 8.4.1, right? So
I'm curious about one thing. Was any research done by anyone about what the phrase prejudicial to the administration of justice has meant in other cases or codes or rules?
there was a big footnote. Remember, Sarah, where did I see there? Yeah, there were other jurisdictions. It was just in the context of other jurisdictions analyzing or interpreting that phrase and how it was applied to incivility. And there wasn't there a footnote that cited to those other opinions somewhere? Do you recall? That's the only thing I remember.
Sorry, I was just quickly looking. I think there is some, but I think I was thinking the footnote is just dealing with how other states have added comments to their rules to interpret that. That's the footnote I'm recalling. Is
Yeah.
there are some other jurisdictions who have comments to their 8.4D that makes clear that that's intended to address incivility. My recollection, I've looked into this in the distant past, is that there's not a lot of authorities interpreting that in California, prejudicial to the administration of justice and how its 8.4D is applied. Although I feel that there are at least one or two cases that have been published that have applied it to reference it in connection with incivility.
The reason I ask is it seems to me there's no doubt that incivility is something that's prejudicial to the interest of justice. But it's not the only thing that's prejudicial to the interest of justice. And trying to cram everything we want to about incivility into 8.4D, I think gives short shrift to other things that are prejudicial to the interest of justice, which says to me, we might want to call out a different rule or a separate rule or recommend that we do, as opposed to trying to put it into 8.4D.
Right. So there are a number of different options here, and I think we should play them out for the reader. Right. So separate rule within 8.4, a separate rule, period, or just a comment to 8.4 seem to be the three options on the table. And unless we reach a consensus that one of those three options is the best, most correct, appropriate, pragmatic choice, which we haven't yet, then I think, for our purposes, the best that we can do is lay out the three options with the pros and cons, including what you just said, Joel.
I agree.
Yeah, in connection with that, I think, Cassie, you already recommended this, but I think we should try to do a little bit of research, because I am curious if any other states have their own civility rule.
I'm running a search right now.
And I was looking at the task force, but it's so long that I couldn't quickly find anything on point. It seems like the states that the report reference didn't have their own civility rule. They just had it as part of 8.4, or some of them did incorporate it as part of the 3.3 to 3.5 group as well. So I don't know if there's a lot more to discuss on this. It seems like as a subcommittee, our next steps would be to kind of follow the path that Justin just outlined, kind of going into more of our analysis. We don't necessarily have to, reach a consensus. We can describe the different options we've considered, and if we don't have a consensus, that's okay. But I think we should set forth the different options, one of which is included in 8.4, and the others of having it as part of a separate rule. But I think we can get into the analysis of that more, because it's not in the current draft, but I think those would be our next steps.
Yeah, I think this type of analysis is really merited because this struggle that we're having as a committee goes to the heart of the efforts to transpose civility guidelines into discipline rules. And so I think it's really worth fleshing out for those who are going to make these decisions, the struggles that we're having, to make sure that they're considering those same struggles when they decide what they think is appropriate here in terms of the final product. So it seems to me, our instinct to spend more time on 8.4 and these issues in the final product that we're going to produce it is a good use of our time. Anything else on the civility rules? So it seems then that we'll do one more round of revision to this document. We'll talk about it in October. And then it sounds like timing wise, we'll need to just work on this as much as we can to finalize it in our October meeting, and then hopefully be in a position to vote it out for the November bar meeting. All right. Just looking to see if we have Dina yet. We don't. I know that Dina wanted to be here for the in-house counsel discussion, so I'm thinking we should switch the order around a little bit and talk about new opinion topics now, and then hopefully by the time we complete that discussion, Dina will have been able to join us, and we can talk about in-house counsel and then end with goodbyes, which seems like a better order anyway. So on new topics, I think at the end of our sort of year, seems like a good time to think about what we would be interested in evaluating for purposes of new topics for the coming year. And so I wanted to open the floor to discussion. I don't know if any of you have had a chance to spot anything that you wanted to share with the committee that you would be interested in having explored, and if not, perhaps we can go through the opinion requests document. I have a few thoughts on that document. But as an initial matter, I wanted to open it up to the group and see what you all are thinking, if anything.
Well, I'm ready to bring up item number 2.
I know you are, Joel. I knew you were going to go there. We've been doing this too long together. I have a note. I have a note on my document, Joel. I was like, he's bringing it. All right, well, why don't we go there? Go ahead, Joel.
Okay. I recently testified in a case that an attorney was suing a client for a fee in a case that was lost, I don't know, $400,000 or $500,000. And the opposing expert started talking about the reasonable standard for attorney's fees. And during her testimony, she admitted that the contract complied with 6148 and the billing statements complied with 6148. So we had to go under this new case of Peck versus Morgan to the contract standard. So I figured it was going to be a pretty easy rebuttal until the opposing counsel brings up advisory 1993-02, which I had kind of forgotten about, but that was adopted on my very first meeting on the Mandatory Fee Arbitration Committee in November of 1993. And it really did a good job in presaging the holding in Peck versus Morgan with one grievous error. And so I pulled out 1993-02 to look at it, and it really could be updated by adding a discussion of Peck versus Morgan, by adding a discussion on what to do when you find unconscionability, talking about the J&M manufacturing case. But then it concludes after a discussion about, as the Peck case mentions, there's also included in every contract, the implied covenant of good faith and fair dealing. And this opinion included, this advisory does talk about the covenant of good faith and fair dealing, but then it concludes with a very unfortunate sentence, which is, hence, a reasonable standard should be applied in reviewing an attorney's performance under a written fee agreement. Right there, you got it. And that's, I don't think the use of reasonableness was fully understood at the time it was adopted. Certainly, I didn't understand fully what that sentence would have meant if I hadn't thought about it at that very first meeting, but it really needs to be changed to bring out that now that reasonableness has been given a technical meaning under the Mandatory Fee Arbitration Act and under 6148, reasonableness is not the proper word there, and it really ought to just be reflected to show that hence the standard for review under a written fee agreement should be under the unconscionability standard and in reference to the covenant of a good faith and fair dealing. And then it could go on and say, in reviewing it under those standards, you can look at whether reasonable care, skill, and diligence was performed, et cetera. So those are the three changes I would like to make. And as we have done in the past with fee arbitrator advisories, we've updated them in light of recent case law. I'd like to take a hand in preparing a revision to 1993-02 to make at least those changes and any others that other people would like to take a look at.
Yeah, I'd like to join in that effort. I think that makes a lot of sense.
I would too. I think it's a great idea.
Count me in.
Okay, great. Well, I completely agree. I read the Peck case yesterday, and to have one of our opinions cited so extensively and positively, for that matter, which is nice, and to be able to build on that to improve or add some nuance to an opinion that's now almost what 30 years old. I think makes sense. So Mimi, Angela, do we need to do anything official here in terms of forming the subcommittee here that's going to work on these revisions?
No, you don't do anything formal. If they're just interested, we'll just put it on the next assignment agenda that I believe, if I got it right, it's Joel, Elizabeth, Ken, and Brandon.
Correct.
Okay, yeah, I could just add it to the next assignment agenda, and that they're assigned to work on a issues outline for the next meeting or whenever they're able to.
Yeah, actually, I think I can go beyond an issues outline. If this is an oldie moldy one, I don't know if there's existing a Word version of this.
I can create one for you if there is. If we can't find it, yeah.
And then the second thing I will need is that I know we had developed a checklist for preparing a fee arbitration award. And I spent a good hour on trying to find the website. I could not find that. So if you could find that, that would help too.
I do have that.
Get all that stuff. I'll be happy to do a first draft, share it with our subcommittee now, and we'll go from there.
Okay, so we'll just go with a draft, revised draft of the advisory and the checklist. I'll send both of those over to you.
Okay, great, thanks.
Let me just write a note for myself.
While we're on this topic, I'm wondering for Joel, Ken, Brandon, anyone else who's been doing some of the legwork here on our fee arbitration related opinions, if there are any other opinions that you think are worthy of considering some kind of revisit update to, other than this 1993 opinion that Joel mentioned, because I don't think that, at least in the 5 years I've been on the committee, we've, well, and only the last couple years where we've had, you know, the fee arbitration opinions on our plate, that we've really given much thought to that. And so I'm wondering if there are other ones that you feel like case law has developed in a certain way that would warrant updating for clarity or otherwise.
We went about, before the committee was disbanded, we went about updating. Yeah, we went through a pretty thorough review and updated a number of them. But yeah, we haven't looked at it, I guess, in a few years now. So they just had, I reached out to the FEARB staff a couple weeks ago because they just had the annual roundtable to see if there were any issues in that regard or other potential topics for advisories that they had in mind or had thought about. And Isabel had said that they threw that out to the people at the roundtable. I haven't heard back whether we've gotten any proposed topics or things that they think need to be addressed.
I believe, and Randy, I don't know if he's with us, but there was a thread between myself, Isabel, and Randy about possibly updating some of the arbitration advisories to make the rule references to the current rule, especially if the current rule was slightly different than the previous rule, the previous California rule. And I think two that Randy had identified was Arbitration Advisory 1998-03, which is about reasonable fee, and 2016-02 bill padding. I mean, we don't have to decide today, but that might be two that you might want to look at and decide if maybe those are worth maybe revising or just updating.
I was gonna actually suggest 1998-03. I haven't given it any thought other than in the last 3 minutes, so I don't have specifics, but since the date of it, 1998, I would imagine it should be updated to include the Shepard-Mullen analysis on when an agreement is declared void for ethical reasons, what the standard is on one, the burden of proof on the quantum merit, and that you don't rely on the contract, the voided contract for what the reasonable fee is. I think that would be a really important addition to this.
We updated that one. The number stayed the same, 1998-03, but it was updated in March 2015.
Okay,
I don't
Shepard-Mullen
remember
was
what
like
year.
August 2018.
Yeah, I don't know. I don't think Shepard-Mullen was addressed in that, but yeah. But yeah, no, yeah, that's fine. Yeah, I just wanted to note that it was updated a few years ago.
Also, Ken, my recollection is that one of the last things we did was to update all the existing advisories with the new rules after November 2018.
Right, and
That was.
of those,
You might have missed one.
the three that I'm aware of that you guys updated, just the numberings, because I think they were just straight number swaps, were 1993-02, 2011-01, and 2012-03. At least those were the big ticket ones. That's what Isabel had told me, according to my email. I can tell you, it's the 1993-02 is standard of review in fee disputes where there is a written fee agreement.
Yeah, that's what we're talking about.
2011-01, which is enforcement of non-refundable retainer provisions, and 2012-03, handling malpractice claims and ethical issues during arbitration. And these three are the ones that I'm going to be updating because they're going to be referenced in the new e-learning course that MFA is creating. But I think hopefully maybe we can revise that one opinion 1993-02 before that is rolled out, that course is rolled out.
So can I make a request of Elizabeth? I think for this one, I think it's 1998-03. I think it would be helpful for the next meeting to have an issue outline for that one that's specific and narrow to what what you would propose or believe should be added with respect to Shepherd Millen and the burden of proof that isn't included in there. And then we can have a discussion about those proposed changes. And then if everyone agrees, we would then get some help and team members to
My
create it.
only, I wholeheartedly say yes to doing it. My caveat is I leave on vacation on Wednesday for 3 weeks, much needed, and I swore I was like, wanted it to be the first vacation in like 10 years that I didn't work. So I'm not sure if I could get it in time to be distributed before our next meeting.
Okay, well, I understand, and nobody wants to interrupt vacations. So if you can do it, great. If not, maybe.
I will commit to doing it. And just, I'm not sure if I could get it in time for the next meeting.
Sure. Okay. Well, then, if we have to hold it off to the
That's
following.
fine.
that'll be it.
I'll take a look at it too. I don't know. Now that Elizabeth mentioned it, I'll see what I can, if I have any thoughts on it and share those.
So that's gonna be a separate agenda item, correct, Justin? It would be
Yes.
an additional for the
Yes.
updating of Arbitration Advisory 1998-03, and I'll assign that to Elizabeth and Joel. Or was it Ken? We just,
Yeah.
Ken.
Elizabeth and Ken, got it. Okay.
Thank you.
And I'll
And
send you
then,
guys a Word version of that as well.
And then Mimi, you mentioned, I think 2016-02 bill padding.
Yeah,
So
that's,
what is that Brandy was talking about? Just, was it the old rules that are in there still, or was there something else that you thought might need to be updated? Because I'm flipping through it and there isn't much, if any, reference to the old, or any rules.
yeah, that one,
No,
no, there isn't. I don't, so if we're swapping in new roll numbers for these two advisories were reviewed, approved, and the versions of English should be replaced with the current ones. I think what it was that one was identified as just being, if there are there's no rule references in here.
I don't think there are any in there that I can think that are.
Okay, then I don't know why that was in this on our list, but it's okay. Don't worry
There's
about
like
it.
it mentions rule 4200 like once. So it would be about 5 minutes of rule cleanup. I was just wondering if there was anything other than this, a couple cleanups here that he was thinking about.
Nope.
Okay.
That's
All right.
fine. Yeah, I think those were maybe two he identified that might be simple swap outs for rule numbers that could be done quickly if the committee agreed.
Yeah.
But yeah, so that's fine. Okay.
Okay, well, I'll just kind of leave it more general then, because we've already picked up on two
Cool.
fee advisories we're going to look at for revision or updating. If others come to mind beyond just, changing the rule to be the new rule site, and we think we need to update something substantively, I think that is an exercise we really haven't spent much time on. And I think, if we have time to do that to kind of clean up, great. It's pretty straightforward. I was thinking really the same thing goes for our ethics opinions, and I haven't given any specific thought to ethics opinions that might fall under the same bucket as the 1993 opinion that Joel is talking about. But it is true that from time to time our ethics opinions are cited in case law. Offhand, I can't think of a recent case that did that. But I was thinking in terms of in our new opinion discussion that we should at least endeavor to look back over the last, call it 10 years and see if there's been any opinions, published or unpublished, court opinions that are in some manner critical of our opinions, and whether that merits rethinking anything that we've said in our opinions, if there's any updating in that regard that we might want to do. I don't think that in my time on the committee, we've really ever done anything like that. And it does seem to be, worth at least a little bit of time to make sure that we're still, up to speed with what the courts are saying is proper ethics advice, and see if there's anything that we need to update or refine. I'm wondering if anything specific comes to mind for anyone, but otherwise, I'm thinking maybe a few of us can work together to do a little digging and see if there's something specific we might want to consider refining.
I think it's really worthwhile because even if they're, regardless of the frequency of being cited in court opinions, published court opinions, they're cited all the time in briefs, in my experience. And people really rely heavily on them in advocating and in both court actions and arbitrations and MFAs and everything. So I think it's an extremely worthwhile exercise.
I'm gonna just mention one thing, Joel, that my hope is that if we are substantively changing 1993-02 in light of PEC, that we do it quite kind of quickly. Currently, the MFA is developing an e-learning program, and I believe they reference that opinion. So if something changes in that opinion or should be added to the course in light of PEC, we should probably have maybe a call with Isabel so that we don't create the course and then have to revise the course in light of any changes we make to the advisory opinion.
Yeah, okay. Well, I'm going to go ahead. When you get me the Word version, I'm going to go ahead and do a draft, a rough draft. I'll circulate it to everybody. You can show that to Elizabeth and she'll at least know where we're thinking.
Okay, perfect. Thank you.
So as far as the ethics opinions go, and I'm happy to be a part of this working group, it would be great to have a couple folks who would just get together and figure out a game plan to do a little digging to see how our cases, or excuse me, how our opinions are cited in the case law, even just eyeball some of our older opinions that might seem a little outdated and see if we need to do any updating. Anyone else want to be part of that exercise?
Yeah, Justin, just as a heads up on that issue is that our training in special deputy trial counsel, we're instructed to look at what were the existing rules at the time of the offense. So if there's been like in the renumbering, we have to know what rules were applicable at the time, and therefore it's helpful to have opinions that refer to the rules applicable at the time they were written. So we want to make sure whatever we do to change that or update it takes into account that issue.
That makes sense. But you know, if we have a 1972 opinion that is just way off base, you know, we won't have that issue. But I agree. If we've
We're talking about advisories, right? Not ethics opinions. Are we talking about both?
I'm talking right now about ethics opinions.
Okay.
Yeah.
On the advisories, do the prior, if there's an update, like this one was updated 2015, does the prior one stay posted so that each version is available to the public?
Yeah, it stays posted, but it says superseded C the next 2016-04 or whatever.
So if you want to rely on,
I don't think they're available though. Like the
Well, that's
one,
right, you can't get them.
1998-03, we kept the numbering and we put the new opinion. Other ones superseded. And then the old opinion where whatever number it was is there and it says superseded. I don't think they're available on the website anymore. I think they took them down.
Yeah, I think you're right.
Yeah, I just checked. It's no longer there.
For the most part, I don't, when they're changed, I don't know why we'd want to keep the old ones up there, because when they were changed and updated, it was because there were either some substantive change in the analysis or new case law or something such that the older version is no longer really applicable. I guess if you're getting at, what Joel mentioned, and maybe, the fee dispute stems back to this. But they're a little bit different because the advisories, even though they've been cited by some courts, I mean, they're really there to help arbitrators with the dispute that's in front of them. Some courts have cited them as authority, but I think that was the thought process why the old ones aren't maintained on the website anymore.
Yeah, for the ethics opinions, it seems that, I think that statute of limitations is, I think for disciplinary complaints is at 5 years. So wouldn't it make sense to, I mean, if we're updating something that's less than 5 years old, which we might not be doing, but if we are, then maybe it makes sense to keep in the keep the old one still up until the statute of limitations period has passed, because it might still be useful. But if we're updating opinions that are older than 5 years, it doesn't seem like there would be much value.
Yeah, and I don't want to get the cart before the horse here. Like I'm not suggesting we should go off and wholesale change a bunch of opinions. I just want to be clear about that. I'm just more at this point want to see what's out there. How have our opinions been cited? Do we have any concerns that we should, seriously consider and potentially revise something? I don't think we should be going back and making a lot of changes to opinions. We're talking about things that seem black and white. Yes, we should make this change because it's going to benefit lawyers making good ethical decisions by virtue of making the change. And so I would envision something very focused and narrow and limited. But right now it's just the feeler stage to see what's out there. So I just want to be real clear about that. All right. Any other ideas in terms of, besides updating opinions, in terms of new topics?
Well, there was one we received from an out-of-state attorney, a request, which is number 1 on the chart. And the other one was number 3, which was from a California lawyer who requested a topic as well.
I want to say, I could be imagining, wasn't number 3, seems to me that was a fairly discussed topic recently on the April listserv.
Yeah, I was just gonna say that that's been kind of fleshed out there. So there's
I
probably,
don't remember if there was a conclusion, but the opinions were flying fast and furious on that one.
yeah, I think there was, I can't remember either, but I think it was dependent on the language of the particular rule on trust. So what is it, 1.5? Well, now I'm blanking, but the
Yeah.
trust rule. Yeah, but that was a good one because there was a lot of debate over it.
Yeah, there was so that might be something we want to look at, but because it was, like I said, I don't even recall that the April people came to a conclusion one way or the other, but.
So I guess I'm trying to understand what this is saying. So a lawyer gets money to pay an expert witness, and the question is where the lawyer needs to put the money before the expert's paid, or is this saying
No, it
something?
was whether the expert, the lawyer expert, and they're paid an advance fee.
Oh, the lawyer is serving as an expert.
Yeah, do they have to keep that in their client trust account? Or would that be a violation or commingling if there are various, different variations of that if they put it into the trust account?
I see.
It looks like there's like 40, well, I want to say, a significant number of posts on the listserv on that topic. I'm just looking at the chain here. Although there could be.
Yeah, there was quite a bit. And my general recollection was, it was, some people said it had to, and some people said it should, and some people said you can't. And a lot of those were based on rules in other states. So, I mean, to the extent that it generated a lot of discussion among ethics people, might be worth at least looking into.
Yeah, I mean, I'm just reading one. So the language of model rule 1.15 together with how it is grouped with the rules. under the heading client-lawyer relationship makes clear that fees for non-law related services are not required to be deposited in a trust account. And then you're there's a commingling issue, it looks like. So it's not a lawyer-client relationship technically, so it shouldn't go into a trust account is one argument, I guess.
Well,
I feel like the language is much broader of 1.15A of not being limited to attorney-client relationships, but I do think that,
Our role, yeah, with
Yeah,
our role,
yeah.
yeah. I know, I think that I looked at that too. I mean, I've only served as an expert witness once and I put my fee in the trust account. So, but other than that, I don't have a whole lot of.
Yeah, and I didn't follow April listserv on this topic. Was the debate among California lawyers, or was it like all different states? So, because it seems like it might be, I don't know, it seems clearer under our rule, but maybe I'm wrong. Maybe if there's.
California was, I don't, like most things on the April listserv, there was people from all across the country. I don't remember who made the first request.
Yeah.
Right.
The California lawyer or not, but and then it branches off into all sorts of other topics, issues and sub-issues. But I know California, there was discussions under California, if I recall.
Yeah, Joel commented.
Yeah.
Sorry, I don't want to climb it up. There's several California lawyers commenting. But yeah, I can't tell where it all kind of came from. Yeah.
And looking at the date of the request, I'm guessing it was somebody who was involved in that conversation, because that was about when all that was going around.
Yeah. Yeah.
well, whether or not it would be a topic that would be, how can I say this? Intellectually engaging to the masses as opposed to those who are ethicists, I don't know, but if there is a lack of clarity here, and we're not weighing in on something that's just, there's clearly no right or wrong answer, but we could offer guidance. Maybe this is something we consider, at least from a issue outline perspective, to delve a little bit deeper into some of the analysis that was in the April listserv and perhaps other places, to see where we think the answer shakes out. And if it ends up being super clear and there's a case on it that we just haven't found yet, and we find it, maybe there's no point of an opinion. But if there is something gray haired where we can offer some insight without making law, maybe this is a good topic. So I'm wondering if
there's a footnote on the lawyers and expert witness opinion. Just kidding. Just kidding.
Yeah, I was thinking that too. I think Sarah might be right though. I haven't compared our role to the other state roles, but it seems broad enough that there really isn't, it doesn't seem like it's a debatable question, because it says all funds received or held by a lawyer or law firm for the benefit of a client or other person to whom the lawyer owes. I mean, that's, I don't know if that is specific, is it, if that would be intended to cover expert witness fees.
Cassidy, there's been an ongoing debate over the past maybe 4 or 5 weeks on the APRL.
Yeah.
List. And I think we've gotten opinions, 35 opinions from 25 different people. So it's
so it's not clear.
You say there's a case on point.
Okay. Yeah, no,
Matter of fact, if you want to just, are you a member
of April? Yeah. No, I pulled up all the.
Yeah, you pulled the digest, so you've got all that. Okay.
No, I have all the extensions. I just hadn't read through it, and I wasn't quite sure if there was a specific comment about California's role and whether or not ours is any different. or broader or narrower than the other rules that are at, that were debated. So, but yeah, I mean, it's worth a look to determine whether or not there is a lack of clarity there that should be addressed. And it would be a short opinion, I presume. Although I don't know. You always say that and then you get into the weeds.
Well, it sounds like people are interested enough in this that maybe we at least start off with an issue outline, and it sounds to me like it could be pretty straightforward and it doesn't need to be very developed. I mean, there either is or is not a clear answer. And if there's not a clear answer, maybe, the issue outline could highlight the differing perspectives and maybe in particular, whatever is available in California, since that'll be most germane, and then we can talk about whether, given the lack of clarity, it would or would not make for a good ethics opinion. So, does that work for everyone to try to look at this more closely in an issue outline?
Sure.
Yeah.
Okay. Any volunteers to be part of the group that will?
I'm happy to do it. I can do it or help.
Is that Cassidy or someone else?
Yeah, that's Cassidy. I don't see even myself on the. Am I
Okay.
actually in the meeting? Yes, I am.
Anyone else who wants to work on this with Cassidy?
Well, I'll jump in on it.
Okay, Joel.
Joel.
Okay.
All right. Hopefully we'll get some other folks as well. Thanks. And Mimi, you mentioned the item 1. I'm not sure that how if anyone had a chance to look at that more closely. So seems this might be a little narrow for an ethics opinion, but
Well, if you guys decide not to opine, then we would, decide not to opine, and then we would send the requester a decline to opine letter. But we should at least consider it. I don't know. Let's see if I can find the original letter.
didn't we talk about this one already? This says August 9th, 2021. I thought we this is looking familiar, as if we had decided not to.
Didn't have a disposition written on it, so I thought it may not have been discussed. If we had, then but we should have decided, though, at that time, if we had discussed it, whether or not to decline or to hold over for further consideration. Let me see.
For me, this feels too narrow to really for us to opine on, and seems to implicate a very specialized area.
That was my sense too. Yeah, it was. In the abstract, not explaining to your clients and admitting that they committed violations without discussing it would seem to be an ethical violation. I don't know if there's something odd in the deportation field that would change that. But.
Does anyone feel like that we should explore this one further, or should we decline to opine?
I'm with decline.
I think we should decline this one.
Okay. All right. Other thoughts on topics, potential topics?
Number 9 is a constant issue. But how to handle sounds more like practice advice than ethics.
Yeah, and I don't know when, Mimi, if you know, because it says requester staff, how old this request is, if this was before the evidence code was changed.
I am not aware. If it says staff, it might have been a hotline staff person who asked
Oh, I
this.
see. Okay.
Oftentimes, that's where sometimes some of our topics come from, is hotline staff says, hey, I had a caller who asked about this. I couldn't find much on it. And so we add it to the list. So it might have been a while ago, though. It's been a few years.
Yeah, it looks familiar. I mean, I think this would be challenging for us to write on. I mean, there's now the evidence code provision, which gives you disclosures for your client about mediation confidentiality, and then and you think about litigation and how mediation confidentiality can affect discovery and what you are and are not able to use. That seems more about legal strategy than ethics. I mean, obviously you can't use something that you're not allowed to use by law. I don't think that is really moving the ethical ball forward here. So, I mean, if someone can see an angle here where this could be a full-blown opinion, love to hear it, but I'm struggling personally.
I don't see I mean, the only one that comes to mind is, I guess, is it an ethical violation if a lawyer does not give the client the mandatory confidentiality acknowledgement notice that they have the evidence code down. But I don't know. I don't know that that's worthy of an opinion. But.
Yeah, I would be reticent to step into that mire. I mean, quagmire. I mean, it's not complying with the evidence code. Whether that should subject lawyers to discipline, I think is kind of legislature to decide, not us. So I would not feel comfortable opining on that if there's no answer personally.
I agree.
Maybe we can make it official to decline that one. Yeah, and I think we've gone through some of these already. I mean, is there any ethics opinion, because we want to keep this moving, is there any opinions that are opinion requests that people saw that they were potentially interested in? Let's put it that way. Okay, well, I had a thought, and this is not well developed at all, but I think the world that we live in is, I think, a lot more self-aware and conscious of people's differences, and so I can't think of an opinion that we've done. Maybe there is one where it had some kind of overlay involving implicit bias and diversity and inclusion. And what got me thinking about this, again, I'm talking really high concepts here. I don't have anything specific, but there's a lawyer a non-practicing lawyer who does a lot of writing on ethics involving lawyers with disabilities, folks who are either for mental health reasons or who are neurodivergent, who have learning disabilities. And I just think it's if there was a topic in that area where we could promote something that would be helpful and useful to lawyers, and also I think embracing people who have those types of challenges, and offer something positive to the world in that regard, I would be, of course, in favor of that. What exactly that specific topic would be, how we would convert that to an ethics opinion, I'm not entirely sure, to be quite honest. But it was an area that struck me. We've had some sort of cutting edge type of opinions with cannabis and diminished capacity, and I got to thinking, well, what are other areas that aren't maybe well covered, but are, I think, apropos of the world we're living in, and so I thought of that. So I don't have anything in particular, but if you get a chance to think about it yourselves, and I will think about it further, I would love to find something where we could write or consider writing on an area like that. But I'm sorry, I don't have anything more specific to say about it.
Justin, I'm a little confused. This implicit bias related opinion, ethics regarding lawyers with disabilities. Is that, I mean, are we going to provide some self-defense advice to lawyers with disabilities? Or are we going to be opining to other people how they should treat lawyers with disabilities?
I don't have anything specific in mind. Again, and I would want to think about that more critically as to what would be the most appropriate manner in which to present those types of issues. So I'm not proposing either of those approaches.
Okay.
I just did a CLE presentation on implicit bias. And I can take a look at it. You know, it certainly covered the ethics issues like under 8.4. And then I'm just try to pull it up, but I can provide some thoughts on that and where the ethics angle comes in. You know, supervision. I mean, there's the duty to, you know, provide training and all of that. And what does that look like? And is that, you know, where the, you know, the ethical violations are, and, you know, what are the best practices? So, you know, I'm kind of just talking out loud myself, but I can go through that and provide some more concrete thoughts if you'd like, Justin.
Yeah, that'd be great. And as a related, unrelated aside, if any of you have Netflix, the Extraordinary Attorney Wu is actually really well done.
I love that show.
It's about a lawyer who it's a Korean show. It's about a lawyer who is autistic,
Yeah.
and her it's obviously fiction. It's like a drama comedy, and her you know, her challenges, and it's very well done. And one of the neurodivergent lawyers who writes in this space has said some positive things about that show in terms of how it presents lawyers who have those types of challenges. So anyway, any other, thank you for Cassidy, and, you know, I'll give this further thought as well. I think it's an interesting subject. Whether it makes for a compelling ethics opinion, I don't know yet, but I at least want to think about it. Any other opinion topics that anyone would like to raise before we move to in-house counsel opinion? All right. Well, please do continue to think about topics you would be interested in starting from the ground level on. I really think that some of the most fun people have on this committee is when they come up with a topic and run with it, and, you know, the opinion becomes their baby. And I would encourage everyone to try to find a topic like that you think would be worth looking into further. I think we have the space right now, the capacity to take on more opinions. So now's a real good time to think about these issues, and we'll continue to have, I'm sure, new opinion topic discussions to keep that those ideas funneling through. So next up, we have in-house counsel opinion. Cassie, are you going to be leading us on this one?
Yes. So, so the opinion is still progressing. It's still certainly in draft form, and we have some, you know, holes to fill in. There's some placeholders, but the good news is I think, you know, I think we've kind of reached some conclusions on the analysis, especially on 1.8.1. And if you guys recall I think at the last meeting, we talked about reaching out, because one of the questions was, well, when in-house lawyers are offered these stock options, or, you know, offered an standard employment agreement that contains stock or stock options, is it typical to have a 1.8.1 disclosure and waiver in there? And we didn't really know, you know, I think we had some anecdotal, you know, at least I had some anecdotal evidence that, you know, I'd never seen it before. So we were going to go back and talk to in-house lawyers that we knew. And I spoke to two, Toby's nephew, who is really helpful. And then my managing partner, my firm, is actually an in-house lawyer for 25 years. So I didn't know that, and I talked to him as well. And both basically said that it's, you know, they had never seen, you know, a 1.8.1 disclosure, and they've never heard of it. And so I think that that's kind of the general consensus out there, is that it's not typical for a GC who's, you know, looking for a job to then, you know, be presented with an employment contract and then have to go through the, you know, go through the 1.8.1 disclosure. So you see in the opinion that we have a discussion of why it shouldn't apply, essentially. And then there's some, you know, there's not a whole lot of authority out there, but there is some. And that's what, you know, we talk about in there. But then backing up to Kyla and Sarah, thank you so much. You guys really contributed here. And in fact, Sarah had some red lines and comments that didn't make it into this version. So I don't know if Sarah wants to go over them, or how you want me to address those, or how you guys want to go through this. But they were really helpful. And then Kyla did the first section on the 1.9, 110, former client, new client conflicts.
Yeah, I put some notes in there that are in there highlighted that I think at one point I called my own sentence weak, but mainly just placeholders. I just wanted to get some ideas down, and then hoping to, and also with Sarah's comments, I was able to read those before this meeting and think about those. So I think we're already gonna have a better draft of that section, but I really just wanted to pay attention during the discussion and see what other folks had to say about it, because as I explained to the subcommittee, I think I'm one of the only members of this committee that doesn't practice in the area of ethics and malpractice and that sort of thing in my actual law practice. So my ability to kind of like work through the analysis and what order things should go in and how to outline it, I think is a little, I'm a little stunted there. So I just wanted to hear kind of how people would actually advise clients on these issues. But with that said, I have a whole list of case law and stuff like that I'm ready to dive into to like actually support some of the analysis that we have in here. I just wanted to make sure I wasn't reading all of the opinions on all of these subjects, especially the stuff like the playbook conflicts. I didn't want to just be reading cases that aren't necessarily going to help our analysis until I heard what the committee had to say. So yeah, I hope that made sense.
Yeah, I mean, I thought your analysis was right, because, you know, one of the issues was, you know, going from one general counsel job to the other, it's kind of, you know, it's kind of hard to look at what's substantially related matter by matter. I mean, to some extent, you know, your job is going to be substantially related to your last job, you know, based on the skills that you used and all, you know, it doesn't really apply.
And I think it's probably extremely common to go from a very similar company to another very similar company. You
Right.
have these expertise that you've gained. You're not going to jump and become in-house counsel at a completely different type of company. And I know that in all areas of California law, we want to ensure that people have mobility when it comes to their careers. So we don't want to say something that's like, well, two tech companies are so similar that every matter is going to be a conflict because it's related. So I wanted to be sure not to step on that kind of, but at the same time, you shouldn't be able to like work on specific patents and then jump over to the competitor and then keep working on those same things. So.
Right. And I think that's where we kind of have to draw the line and just, you know, apply the existing rules to the in-house context. And I think, you know, it's shaping up to be like that. So it is flexible enough for the in-house lawyer. And that was my other, you know, when under the confidentiality section of that first part, one of the questions I have is whether or not we want to raise, so like, and I think Kylie, you had a question. Let me scroll down. Let's see, you keep going, sorry. Okay, so you said, okay, so like the policies of the old company to keep certain proprietary information secret. So if you have a non-disclosure agreement, that's so broad that you really, your hands are tied to go to the next, you know, a somewhat related company, because you can't really disclose or talk about anything that you did at your old company or use those skills or whatever. I'm wondering if we want to discuss whether or not those types of non-disclosure agreements violate Rule 5.6, or if that's just opening up a big can of worms. Because, you know, then it's sort of like a non-compete clause, right?
Yeah.
And then, so you know, that's kind of what I wanted to pose to the committee, if anybody had any thoughts about that. No.
Hi, can you hear me, Cassidy?
Yeah.
Hi. I actually thought about that same issue. And because I think in most of these circumstances, when you have in-house counsel that work in these particular fields, they are going to be signing standard employee agreements related to confidentiality, right? Like a broader. So the question is like, how does that intersect with their duties as an attorney?
Right.
I think it's worth noting it maybe in a footnote or something, because I think in this type of situation, that's going to almost always be the case, that they're going to be asked to do that when you're dealing with, particularly in our hypothetical with like involving technology and software. I just think it's pretty commonplace. I mean, the agreement itself, I don't think we want to get too much into analyzing whether the agreement could do certain things, because it would have to be permissible on its own, right? So, so I mean, I think, you know, if we were going to note it, I would say note it in a footnote, because I do think it's going to be a common thing to happen. And usually you're looking at both that, and you're looking at, you know, when you're trying to analyze the conflicts, right? You're going to look at the scope of what that is. If you were doing that type of work for an in-house counsel who is moving to another company in that situation.
Right, because the focus of this opinion isn't really about that, right? So I think putting it in a footnote.
Or you could say in a footnote and say like, we're not addressing like the, you know, because we'd have to have some type of an analysis of that particular agreement. But I think just noting that we're either not going to analyze the impact that would have on the duties of confidentiality. That's a separate issue, right? But recognizing that it's sort of commonplace that they would have to be separately analyzed, you know.
Right.
Maybe that's the approach that would.
Yeah, I'll work because you want to, you know, I guess if we're getting into like a screening question as well, that if you are, the scope of the non-disclosure could be so broad that the screen is coextensively broad, like you're screened off from everything. And so that might be, so I guess my point is that there is some crossover with the Rule 5.6 issue and the conflict issue.
Yeah.
But I think it should be dealt with in a footnote in any event.
Yeah, I think either way, how we decide to deal with it should be like a footnote, I think.
Okay.
Yeah. On that, are you still talking about the first section on that screening question? First of all, I thought that you guys did a great job with this, and I was kind of looking at Sarah's revisions too when I was reviewing it, but Kyla, you did a great job with the section, and I like your additions to it, Sarah, and Cassie, you guys have just done a great job of working this up. I think with the screening, I mean, I think the conclusion is obviously in this situation that there's no conflict, so that there's no duty to screen. I think that's an important to capture in the opinion. And I think I've seen people try to argue in this situation that because you have confidential information that you should be screened off, like as a sort of a preventative from all of these things in that way. And that's not what the ethical rules say, right? So I think I would say, as you guys work up the opinion more, that you want to have that conclusion that it's particularly in here in this fact pattern, there is not a conflict, right? There may be in the future related to confidential information that this person possesses, or if they take on some type of different role, but there is not a conflict now, and so there's not a duty to screen. And you could talk about, even maybe in a footnote from a risk management perspective, somebody might decide to screen for particular reasons, but that would be based on a decision that in-house counsel would make that's not related to an ethical obligation, from our analysis here, right? So there's not a conflict, and so there's not a duty.
That's good to hear, because that's kind of where I got to, but I think I was still in the mindset of like just trying to scorch the earth of everything, and like approach it like it's like the bar exam, and you just write about issues that aren't even there. So
yeah,
like,
and I mean,
got to a dead end, no conflict, so no screening, and then I was
right.
like, oh, it can't be that easy.
Yeah, exactly. I think Sarah's like in her draft that I'm sure be incorporated in the next version that people are looking at. She included, as you guys, Cassie and Kyla know, there's much more detail about some more analysis about how the facts don't lead, they're not substantially related in that way. So there's more like factual analysis that support the conclusion that's being reached ultimately, right?
Yeah, and that's
some
where
of that
I
stuff.
could grab some more case law in point, and find a case where that they say this is not substantially related because of X, Y, and Z, and then use our facts as well, for sure.
Yeah.
So I had a quick thought about the screening issue, which is just that I think this is a very, very interesting and really dense draft opinion so far, dealing with a lot of complex issues. And it occurred to me that if you have a 3-person legal department, I'm not sure a screen is doable,
Right.
is it? Even permissible. I don't know whether we want to wade into all those considerations, but if we are going to talk about screens, we might need to at least mention that, under certain circumstances, they might not even be able to be created.
Yeah, that's a good point. I mean, the screening issue, in my mind was coming up with, working, having the lawyer stay away from certain technology that is so related to the old company's technology, and that would be a kind of a cleaner screen. And so, in a 3-person legal department, that could be possible, I guess, but maybe not, depending on,
But do you agree, Cassidy, that would be more of like a preventative risk management measure as opposed to an ethical duty based on this analysis here that we have?
Yeah. No, I think that's right.
Yeah. I think the other thing we talked about at the last meeting, trying to capture even in like a 1 or 2 sentence in a footnote, was the concept of like, if this attorney, and I'm not sure exactly I didn't really think about exactly where to put it, but if the in-house counsel is trying to examine whether or not, like doing some analysis about whether there is actually a conflict that would require them to be screened off from certain matters, they would need to discuss that with, in all likelihood, outside counsel, right? Because just they have confidential information, and the idea that they would talk to somebody at the company about, hey, I know this particular thing. I mean, they'd have to be very, very vague, right? To get any, and it would be difficult for someone in-house counsel, I think, to give them, to really be able to give them good feedback on whether or not it was ethically proper and appropriate for them to institute a screen based on a conflict without disclosing like the essence of what they think the conflict is about, i.e. the confidential information, right? So that's something that is typically, in-house departments use outside counsel for those purposes, right? So that's something to note too, I think.
Okay, yeah, no, that's right. Okay. Okay, so I think we are on our way for the first portion. Was there any other thoughts I had? No. So is Sarah still here? Oh yeah, you are. Sorry. Did you have any other comments about the first portion?
I'm just going through no, and I think my comment on the screening was off. If I'm looking at it, it doesn't make sense. So I would just disregard that as I'm looking at the comments I had. So, but no, I think we went. I don't have anything else to add on this section.
Okay. All right, so we'll just develop this a little bit more and we'll put the 5.6 add the footnotes, but I don't think we need to go into great detail about the lawyer mobility issue. And then same with the screening issue. Okay, so the next part is on Rule 1.8.1. And essentially we came to the conclusion that it shouldn't apply to these types of employment contracts based on, scroll up. Based on the fact that, the purpose of Rule 1.8.1 is to address the unequal bargaining power between lawyer and client typically. And so when you're taking an ownership interest in a client, that sort of thing, you have to comply with the rule because there's a risk that the lawyer is going to take advantage of the client in that scenario. And that's not the case here, I thought that the, what's the name of the case? The California case that I said, General Dynamics case had some, even though it's a different scenario, it had some really good language about what it means to be an in-house lawyer and how, the power dynamic is reversed. And so I thought that was helpful here. But I do agree with Sarah that I can condense that in, the discussion about General Dynamics at the front. And then the other reason why it shouldn't apply is that like in the Chisholm case that we cite there, and then the ABA's report basically says that these types of agreements are like standard fee agreements where 1.8.1 doesn't apply. That doesn't really kind of click in my mind as much as, the fact that this isn't your typical, lawyer taking advantage of a client situation, but that's, so maybe somebody can explain to me that, But the bottom line is I don't think it applies. The caveat though, is that when you have a situation where, the lawyer goes into business with the client and they form a company together and then lawyer takes the title of general counsel. I think in those scenarios, that's where 1.8.1 applies. And that's where the Fair versus Bacardi case comes into play, where we need to distinguish that type of situation because it's not, not every general counsel can avoid application of the rule. It's just in situations where, it's part of a standard employment contract that's, being offered. Well, it's basically part of a standard employment contract. It's not something where you're, forming a business, making a proposal to a particular to a client.
Yeah.
No, go ahead, Sarah.
I was just saying that's a very good point that you just made, and I think we should probably address that, maybe even in a footnote, explaining again that we're not addressing that type of situation, just given the frequency of kind of startup companies in this area where that situation might be fairly common. So I think adding a footnote to address that would be useful.
Yeah, so I mean, I think we need to make the distinction between, you know, applying for a job as an in-house lawyer and, you know, the terms of the offer are being offered by the company to you versus, you know, being part of forming a company, proposing, you know, and you're advising the client in the formation of the company or formation of the deal or whatever it is, you know. And so and here, and that's the other point too, is when you're applying for a job as an in-house lawyer, you're not advising the company in connection with that transaction. You know, they should already have, I guess, an in-house lawyer or have counsel on advising them about their employment contracts that they're going to be offering to, you know, their employees, including in-house lawyers. So I need to draft the language to clearly make that distinction, because I think there could be some confusion there.
If I may, I had a couple thoughts on that, which I think I may agree with all of your conclusions, but I want to be really careful how we address why 1.8.1 wouldn't apply to this situation. I think one of the key things was, as you talked about, you mentioned in there, but we might want to stress further, is that the offer of ownership interest came before the attorney-client relationship was formed.
Right. Yeah.
And when it comes after, even if it is, I've actually had a couple cases where an in-house counsel suggests to the company, small little companies, I think we should give everybody stock options, and then the lawyer drafts the stock option that also applies to the lawyer, and that's a different situation. So so I've just seen a lot of people wade into dangerous waters, and I want to be clear that we are giving them some important distinctions between this unique circumstance and others. I think you're doing a great analysis here. I just want to hammer that home.
No, I agree. I mean, I'm kind of struggling. There's all kinds of, like, you know, distinguishing factors floating around in my mind. And that's definitely a significant one, which is, you know, the offer being made is being made by the company. There's no attorney-client relationship. I mean, that's kind of the demarcation point, because you're right. After you've been hired and you're expected to advise the company on all these things, including, you know, bonuses and compensation and all of that, and it includes your interests, then you know, rule 1.8.1 should apply, I think. Yeah, but so does 1.7. I think, which is the next part of this section.
Before we get to the next part, I was wondering, some of these nuances that you've just discussed, Cassidy, is that what is meant with there's a bracketed statement at what was line 312? It says discuss debate among commentators. Is that what you're talking about right now, that there are situations where 1.8.1 can apply, and so commentators have gone back and forth about that? Or is there actually, are there actually jurisdictions that wouldn't agree with the Chisholm case and similar cases? I wasn't sure what that comment was relating to.
Yeah, I mean, so I'm trying to remember. There's a lot there. There does seem to be a fair amount of kind of discussion about, you know, the role of the in-house lawyer, and just the penchant for there to be a conflict based on their own personal interests, whether or not 1.8 comes into play, or if it's really truly dealt with under a 1.7 situation, you know, 1.7 analysis. I can't really recall. I mean, there's, you know, the commentators don't really discuss the Chisholm case. There's not a whole lot out there at all on whether or not 1.8.1 applies. I accept to say that it doesn't apply in these
Okay.
types of employment contracts. I couldn't find anything, and I'll have to go back and look because I can't remember what I was thinking when I
Yeah,
wrote that.
because when I read this, and I go through the Chisholm analysis and the ABA analysis, and it seems like, okay, well, we're on solid
Straightforward.
ground here. There's no debate. And then you get to this, what was line 308, and it says, well, actually, this question about 1.8.1 applying to hours employment hasn't been addressed in California, and then cites fair, and then says discuss debate among commentators. So it left me wondering, how strong ground are we to say in California that 1.8.1 wouldn't apply to an employment offer unless it's one of those unique circumstances that you outlined, such as when the lawyer is, helping to form a company, is going to get stock options in that company, and is going to benefit from the formation of the company with the client, and situations like that. So I think we'll want to refine that as we go along, and I think be as clear as we can about how far we can go with
Right.
interpretation of our own California rule based on the law that applies in California, and then reach out to the other jurisdictions in ABA to support our argument.
Yeah, no, I agree. And so one of the other issues that came up, and what I wanted to ask, is whether or not 1.5 applies to these compensation agreements. Whether or not an unconscionability analysis has to apply to the fee that the lawyer is agreeing to. And that is a subject of some of the commentators. And I think that they say that it does and it doesn't. I mean, if it's not, if there's no, unequal bargaining power, for example, then how could it be an unconscionable fee? It just doesn't make sense to go through, but that's I did not do that analysis yet, but I was curious what anybody else thought of whether or not the lawyer has to go through that thought process when they're being offered, a stock option package, or even comp, when they're being hired as an in-house lawyer. Does 1.5 apply?
Is it more of a salary than a fee?
Right. Yeah. Is there anything out there that says that a fee can't be a salary, and vice versa in California? I mean, the Chisholm case basically says that. But I was kind of the Misakian case gave me some pause because it applied the 6147, regarding contingency fees to an in-house lawyer, where it was agreed that the in-house lawyer, part of its compensation would be a percentage of whatever the recovery was on a case that they handled. And I thought that was kind of, and there was no written, it didn't comply. And so the court said that you don't get your contingency fee. And so I thought that was kind of harsh in this scenario. But Sarah made a good point, is that, that the purpose of the purpose of 1.8.1 and 6.61 and BMP code 6147 are different. The purposes are different.
There's also the overlay that many in-house lawyers are not just getting a fee for legal advice. They wear business hats too.
Right.
And you get in that, I've squabbled with that in discovery many a time, where folks are trying to get attorney-client privileged communication, saying, no, the lawyer was giving business advice. They were just copied, right? And so it wouldn't be, assuming 1.5 applied, it would not be a linear analysis, because one, I think, can colorably say that fee that the lawyer's getting, their salary, isn't purely or per se for legal services. It can also be for business advice.
Well, yeah, and so I'm wondering if we put that in a footnote somewhere. Because again, this isn't a conflict. That's not really a conflict question. Or really addressing conflict. So I guess that's kind of a note for me. So that is to address whether or not 1.5, where 1.5 fits in here, if at all, and to put it into a footnote.
I'm still, yeah, I'm still thinking back to the 1.8.1. I guess the concern I would have is if you've got the stock option interest, that's kind of like a personal pecuniary interest that could otherwise impact the advice you give to the company. So I'm trying to play through the fact patterns in my mind, but it seems to me, an in-house lawyer's advice on particular business issues could be impacted by their stock option interests. I don't know. I haven't read that Chisholm case, but I'm not sure. It seems to me that's like a different fact pattern.
Well, I think that's taken care of. That issue that you're raising is taken care of under 1.7. It's not that the lawyer who has a significant ownership interest in the client, by virtue of being an in-house lawyer and is immune from having to comply with the conflict rules. It's just that it doesn't fall under 1.8.1. But it does fall under 1.7 to the extent that that personal interest, the stock, materially impacts their representation, their ability to give the advice about, all kinds of things. And that's the other discussion point. To answer your question, I mean, I don't know if we're done with 1.8.1, but we can move on to 1.7.
Yeah, and Cassidy, just one other point on 1.8.1, and I put this in my my comment, and I know the Washington ethics opinion analysis that was very helpful that you included, but is focusing on a comment to Washington's rule, and our rule also has that similar comment, which I think is helpful in this analysis, and we should apply more, which is comment 6, which says the rule doesn't apply to standard commercial transactions for products or services that a lawyer acquires from a client on the same terms that the client generally markets them to others, where the lawyer has no advantage in dealing with the client. And I think it's analogous to that type of situation.
Yeah. I mean, the way I read that, I agree. But in the way I read that was like if the lawyer, has a mutual fund and they have, it includes stock in the client who's a public corporation or something, right? I mean, so that's how I always read that comment, but it still would apply here because you're saying that it's the same type of terms offered to other employees, and there's no basis for the lawyer to take advantage of the client under these circumstances as well, just as the lawyer buys stock in a public company that happens to be a client.
Yeah,
is that right?
Yeah, I agree. It doesn't. I agree. It's not like a direct application to our facts, but I just think the way that I think it's the Washington court, an ethics opinion, if I'm correct, in my recollection, the way they interpreted that very similar comment in Washington's rule, I thought was I agreed with that analysis is all I'm saying. And I think we could, offer something.
That up. Yeah. Well, the thing is with the Washington ethics, I guess it's an ethics opinion. It was just like a conclusory opinion. I mean, the court is what goes into more analysis in the Chisholm case, but I don't know what the Washington State Bar was asked this exact question and just said no. but without any analysis.
Oh, okay.
Yeah, so I mean, I think what I have in here is what they said. That's it. That's all they said.
Wow,
Just the one
okay.
paragraph. Yeah.
And quick question, do any of these opinions, because I haven't studied them yet, address the application of Rule 1.5?
No, not the opinions. I don't, there's no really many opinions at all on this particular issue, but there's law review articles, and there are a few that talk about 1.5. It just, on like in-house counsel compensation in general, how do you categorize it, And so it touches on 1.5, and then it talks about the conflicts issues as well. There is a fair amount of commentary out there, especially after the whole Enron scandal and all that, where were the lawyers and advising these clients, advising these corporations and staying out of trouble. And a lot of it was, well, the lawyers were also conflicted. And so they had a financial interest to basically perpetuate the client's, bad acts. And so that's kind of where all of these commentators arise from, but that's not really what we're talking about so much here. But yeah, so 1.5, there is some, and I'll have to go back and look and see if it makes sense to plug it in here.
Because I do think it would be helpful to address it briefly, even if we don't go into too much detail.
Okay. Okay, and so if we want to move on to 1.7, I mean, basically, the ABA opinion on the one hand is helpful, on the other hand, it's not so helpful. But and even the ABA report says 1.7 does apply. I think it just applies differently than in your typical, law firm lawyer context, because the in-house lawyer, when they're advising their client about all kinds of issues, they're always to some degree influenced by their own ownership interest in the client, in the company, and those interests are typically aligned with the company. Everybody's kind of rowing in the same direction, and so it shouldn't, and every time you give advice to the company about a financial issue or stock or what, you shouldn't have to give, you shouldn't have to have them sign a conflict waiver. And so that's kind of the struggle. At what point does it arise to a material limitation? And so that is what I'm still kind of struggling with. What are the hallmarks of, how do you provide that guidance to the in-house lawyer? So, and I thought that the ABA opinion was helpful in that respect. So, I think the block, there may be other circumstances with the lawyer's ownership of stock in our corporate client conflicts with the responsibilities as the corporation's lawyer. For example, the lawyer may have a duty when rendering an opinion on behalf of the corporation in a venture capitalist transaction to call upon the corporate management to reveal material adverse financial information that's being withheld, even though the revelation may cause the VC to withdraw. And so that might be, contrary to the lawyer's financial interests. And I think that the message there is that the lawyer has, some latitude to evaluate their, whether or not their professional independence is going to be materially impacted. So, I mean, I think that's probably what the message is going to be here. I mean, when I was talking to Toby's nephew, and I'm sorry, I'm blanking on his name. He, basically it was, he basically said that you don't, every day there's some sort of kind of conflict that comes up, but it's just, the only time you would get a conflict waiver is if it's more of an unusual circumstance, something that's kind of out of the ordinary. And that's what we're, I'm trying to figure out where the line should be drawn. So any insight on that? I'll pause there if you guys have any thoughts on, when a 1.7 conflict waiver would be required. Or if there's even a non-waivable conflict situation where you have to withdraw,
Or you have to divest, perhaps.
or divest, right. So, okay. I will continue evaluating or fleshing out this issue. But the conclusion is that 1.7 does apply. I mean, it's just in what, at what point does it apply? Under what circumstances? And then the final section is what I still need to draft. I mean, it's really just a placeholder at this point, but it's advising whether or not the in-house lawyer can advise individual shareholders. And, the conclusion there should be that they can, with the proper disclosures and waivers. So are there any questions or comments? Nope. Okay, so that's the end of it. So I should be able to have a fuller draft or a completed draft to go through the language in more detail and the analysis in more detail at the next meeting. We can finish it up, and I can certainly work on it. So that's that.
Thank you for taking us through that, Cassidy. It's in wonderful shape, and looking forward to seeing the next draft. And hopefully we'll be in a position to provide even more feedback and get it to the public comment phase in the next few meetings.
Thanks.
And anything else that anyone wanted to say about the in-house counsel opinion? All right, well, we've, I think, reached the end here of our meeting. It's always sad when it's the last meeting of the year. I want to thank all of you for your participation and efforts this past year. I wish personally I'd been able to see more of you face to face, and I hope that in the coming year that will be possible for those of you who are able to continue on with the committee. But really, we can't have the success that we do as a committee without everyone's working as hard as I know you have. And so thank you very much. I want to say especially to those who are leaving us. Toby, I can't tell you how much we appreciate your insight and perspective as our public mender for so many years. I also remember running into you at the airport on a random day in Burbank. So we actually got to see each other over once at least over the last few years, which I appreciated. It's been a real pleasure to have you on the committee. Having a public member devote so much time and thought makes the world of difference for us, because you see things in a way that we can't. And so thank you so much for being a part of this committee. Before I get to Dina, Sarah, I just want to thank you for being the vice chair this last year and your really unwavering contributions, not only in the meetings, but there's so much that goes on behind the scenes to get ready for these meetings and to work up opinions. Sarah has been as diligent as a member as I've seen in all of my years, and we would not be as successful and productive this year or any of the years that we've been so fortunate to have Sarah here to move us along. And I'm sure, along with everyone else, looking forward to your leadership for starting now. And I have to say that above all, I appreciate your Zoom backgrounds, which have given me so many ideas for my dream home that I hope to have someday. So thank you for that. Dina, I hope you can hear me. I just want to say as well to you how obvious it is to me what an indelible mark you've left on this committee. Opinions like the lawyers departing law firms, your successor planning opinion, which we will marshal to its conclusion. You've left a positive brand on this committee and given us, I think, a certain sense of diligence and knowing what it takes to take an opinion from start to finish, as you've done on many occasions. And I want to thank you for your dynamism and your commitment and being a force on this committee for 6 years. You've been a sounding board this past year for me and Sarah. And I'm glad that at least at the last meeting, we were able to actually sit 2 feet from one another and have that at least once this year. That meant a lot to me. Last but not least, I want to thank the staff. As I said earlier this morning, I mean, half the Zoom windows were staff. I think that the State Bar, also recognizing some of the transitions with Andrew leaving, has really stepped up and given us resources and support that we needed to succeed, especially in this more challenging environment, doing this remotely. So, Randall, Mimi, Erica, Bridget, we've appreciated your support this year, and we know how hard you work behind the scenes as well. And so thank you on behalf of the committee for all that you do. And if anyone else wants to say something, go ahead, but I just wanted to say my piece.
Yeah. Oh, did you want, I just wanted to also say, I'm going to greatly miss, and I echo all Justin's comments, but I'm going to greatly miss Toby and Dina. I know it's your last day today on the committee. And Toby, I think you offer such thoughtful and insightful feedback that really helps to clarify and focus our opinions. And I really appreciate it. And I'm happy that I got to work with you briefly on the subcommittee for the Civility rural amendments. And I thought some of your comments and feedback were great on that too, especially just today, where you talked about having civility be a separate rule, and not necessarily delegated to a comment 8.4. I thought that was a very important recommendation and something to consider. So I just wanted to say goodbye, and also how much I've appreciated all the contributions you've made. And Dina, I also am going to greatly miss you. I really have enjoyed your leadership style. For me, when I first joined the committee, I felt so welcome. I know on the committee, and it was easy to contribute because I feel the way you lead and seek feedback from others. It's a great leadership style that I really appreciate. And you're direct, and you're also concise in your writing style too, and you really help out a lot. When I've been on subcommittees with you, it always makes the process so much easier. And of course, the scope of your just ethics, knowledge, and expertise has been invaluable. So I will really miss you. So I wanted to make sure I said those goodbyes and thank you to both of you. Luckily, I'm glad that Justin will be staying on as an advisor, which I will greatly appreciate, given that I know I'll have to turn to him for advice, and he's been very helpful throughout this time as well. So, and of course, as Justin also mentioned, I really, I thought when Andrew left that, I really thought he was so, I still think the same thing, like, oh, he's irreplaceable, but the support that we've had since then has just been great. And, I already mentioned it earlier, but just with the putting together the, Civility subcommittee, it was a lot of work to go through the, the revisions to the rules, but having that kind of, a lot of the work product that Erica helped was very useful. And I feel like whenever I go to, work on a subcommittee, the stuff that Mimi puts together with just the comments and recommendations from our meetings have been great too. So thank you all. And I just wanted to make sure I briefly said my goodbyes to Toby and Dina especially. So
I want to say thank you also to everybody who's here and for a lot of people who've rotated through over the last years. I've been here 4 years. It has been just a great opportunity and an honor. I've learned a lot and gained a lot of perspective through the years. I particularly want to thank Dina for a number of times in the last few years for some offline discussions and sort of research that I've done or that she's helped me with. And Mimi and Angela and everybody else who has helped. I just want to say thank you. It has been great. And I wish you all a lot of luck going forward.
Yeah, I'd like to say a few things too. I'm so appreciative of those comments. It has been 6 years, and I could not have imagined that COBRAC would be so monumentally significant to me, both personally and professionally. I mean, I feel like I learned to be a better lawyer, ethicist, collaborator by working with all of you and those that I worked with before during my time on the committee. I don't know, research and writing, revising opinions, considering rule revisions, and other important things that we do that are really important to California lawyers and the mission of the bar. And I've also learned, like we learned with many things in life early on, that the more I put into this, the more I got out of it. So I really like my efforts in being a part of leadership and being like challenged and pushed by all of you in terms of how really digging deep and thinking about things really made me better at this and made me I got a lot more out of it because of that. So I will be forever grateful for the opportunity. But I'm excited to see COBRAC and its members continue to do the great work that it does. And I know you all will. For staff, Mimi, Randy, Angela, Lauren, thank you so much for all your support and hard work and dedication, thoughtfulness and caring, and really treating our committee like it seems like we're the only committee that you have. And even though we know you support so many other things, you've always given us all of your attention, it felt like. And so I appreciate that. Special shout out to you, Mimi. You're just the best. You always go above and beyond. You make everything look so easy, and it just makes these things run seamlessly. So I'll miss seeing you and interacting with you. And so I'm glad that you're still there and that everyone still has you though. So that's great. Toby, you've been an amazing public member. I feel like, as we all know, we discuss and analyze these dense and tricky issues that many lawyers might have difficult tracking, but you never let that get in the way of your understanding or desire to understand and contribute to the committee's opinions and work. Like I echo what Sarah and Justin said, there's always thoughtful, insightful things that you contribute in a kind way. And I've always valued your perspective which is a really important perspective to have on the committee. And so I do hope that our paths cross in the future. I really enjoyed getting to know you over the past 4 years. Sarah, you were one of the members from day one that was always ready to go and contribute. I mean, for many of us, including myself, it takes a while to get your feet wet, to find the right role for yourself, to find out how you can best contribute and integrate into the committee's work and the opinions. Because as we know, it's like when we join, things are already in motion, right? But you were just one of those people that were like, from the get-go, you were just already, you could just turnkey, you were there, you're contributing. I mean, as what Justin said, I mean, your dedication and diligence and hard work is like, I mean, it's unmatched. You take on so much, and you don't just take it on and do it like haphazardly. It's always thoughtful. You always have great things to contribute. And so I just know that COBRAC's in great hands. I'm so excited for you to be the chair next year. You're going to do a tremendous job. I know that. And then finally, Justin, it's just been such a pleasure to work with you over the past 5 years. both personally and professionally. I could not have asked for a better colleague and lawyer and ethicist and human being to join leadership and to work so closely with year in and year out. I mean, you know, we've worked together for so long, and when you think about that, it's it's nice to be able to work with people that you actually like and respect, and make you better and think of things differently than you do, which makes the process work better. So you've led with such a steady, thoughtful, and deft hand, and you just always have a tremendous eye for spotting the little things. I mean, the big things too that other people notice, but I mean, you spot those little things that are important that a lot of us don't always notice. And so that's one of your great strengths, I think, is seeing all the details. But I have no doubt that you'll continue to make an important impact on the committee as an advisor, of course, and I will miss working with you and connecting with you with the COBRAC meetings. And it was really fun to see you, and for our little group that was in person, that was really fun to be able to have lunch together. So anyway, I will miss you all, and to the other members, it's been a great year, and I'm so excited that you guys are all going to continue on, and I'll miss you, but it all goes on and it'll be great. And we'll see you around.
Thanks, Tina. Thanks, Toby. Thanks, everyone. I hope you all have a wonderful weekend. And if there's anyone else wants to say anything, sorry, I didn't mean to start anything. No, okay. All right, well, thank you, everyone. And
before we sign off, I just want to remind everyone who will be at the next meeting that the next meeting is in person and in Los Angeles. And so look out for an email from us about the logistics on how to book your flights and whatnot if you haven't already gone through that exercise.
looking forward to it. Thank you.
All right. Thanks, everyone.